What he wants to say, do you know? Do you know? What is
that KGA is suffering from
still he should come and argue the matter.
Last occasion,
What to do? Bacteria and virus, they do not obey our orders. He's not very some short day.
Advocate is to argue.
Well, that will actually trace the memory. Matter, your lordship, by granting 2 months' time, as the committee has been constituted to take a decision, therefore your lordship posted to the no further adjournment will be given. AG is to appear and argue because on their prayer that
but arguing
Mr. Ponda is to assist well to the blood order.
I am just replacing the memory.
Only I am lordship.
That day again.
13th May, next week 13th May. 13th May. Only that much May.
13th we have posted for matters. One compliment. So.
I was requesting for 13th, so please have it some other day in my matter.
because you want that day.
12 or 11?
19.
13th May.
So just work till vacation. Yes.
You pay.
There is hope. That is why they are doing all this. Always live with hope.
Just to hope, but the hope is there.
They see hope in your lordship, therefore they are troubling you.
The 18th is this one. 19th we have.
May 13th or after vacation. 13th or after vacation.
No after vacation.
13th.
I may not be here. Whatever justice we want to give, we will give.
Tension matter on all, it's not day by day.
Yes, my lord.
Number item.
We'll have it 13th.
My case, your lordships are taking it on 13th, so my case can go to 14th.
14th.
I don't mind. It will be on 13th if it doesn't. That matter
then
doesn't.
you can push it to 14th.
But item number 1 is what I was wanting for 13th. I will file a rejoinder by Friday. And there's a small EA for substitution that may be allowed. The name of the company has changed. The petitioner's name has been changed from Bhushan Steel and Power Limited, like F. So that may be allowed.
Yeah. So supported by affidavit seeks a change of nomenclature of the
Grateful.
petitioner company.
Yes, well.
Petitioner company. From so and so to so and so. Application allowed. There being no objection. There. But in our circumstances, application has been allowed and the petition permitted to amend the cost rate.
Grateful.
Accord.
My learned friends.
My lord, I am appearing for the commission, my lord, OERC.
Under by Friday.
Friday.
Yes.
My lord, I am appearing for the commission OERC.
Yes, sir.
And my lord, we have filed on IA number 8576 of 2026 yesterday for placing on record certain orders and notification, my lord, that application it will be useful in the IA number 8576 of 2026.
So lordships are calling it on 13th.
13th. We are
Grateful.
13th.
You may be allowed to file reply to that.
Why allowed? You are as a matter of right under your.
So I just wanted to mention that. So, my lord.
Yes.
Obligement.
Obligement.
Pass over. Any urgency? Mention matter. Alex, pass over.
Chemically, your lordship. Lord, I have taken the order passed by the Central Administrative Tribunal under Annex 1.
For 5 minutes, then only. Or come in between. Do it. So many hurdles in getting justice. Yes. some good connection. Go for assessment up to 11:45. Then you do whoever is present. Yes.
I have challenged the order under Annex 1.
I've got the district petition.
Petition is given to you.
Yes, but I have already.
When the caveat is filed.
19/9/2025.
And then
Not, I have got a copy. That I have got a copy. I am the sole of this party.
not come.
Not,
It has not been admitted.
Not a statement.
Not admitted.
But your name is not shown.
non-so. But I am.
No, but caveat expires after 90 days. But 90 days are over. You have not renewed the caveat.
But anyway, I am the sole of the party. I have the authorization to appear.
How did you appear?
And I have got the
But
copy.
caveat dies after 90 days. It awaits. Yes, sir.
My lord. Your my lord, I have challenged the order under Annex 1 by which the Law and Central Administrative Tribunal has directed to pay a second MSCP and
MSCP.
third MSCP, my lord.
Second ACP
And
and
third MSCP, my lord, at the pre-revised scale. He was granted second ACP and third MSCP at the grade pay of rupees 5,400 and 5,000, my lord, at the scale of,
Where is your entitlement?
yes, my lord, 5,000, 4,800 and 6,600.
Correct.
But-
Where is your entitlement?
But his entitlement, he is not entitled to grade higher pay.
You are for the central government.
I am for the central government. In view of the fact that the post was, the very cadre was reconstituted and as subordinate statistical service cadre. And he did not opt to join the subordinate statistical service cadre. As a result of which, my lord, there is no question of stagnation, or therefore he is not entitled to the benefits which the persons, those who have joined against the cadre. But he is claiming equal benefit as those persons who joined against the cadre. My lord. So we have challenged the order on that ground that he is not entitled because he preferred not to join the post and for a
Whether
consideration.
option was there with him?
Yes.
Option was with him.
No, he has exercised options.
He refused to join. So
If option is given,
my lord,
no option is given, then you are right.
my lord,
If option is given, either to join or not to join, and he exercises the option to remain there where he was,
yes, my lord.
then can it be a ground to deny the benefit?
But the cadre rule will not be applicable to him, and he was holding a isolated post, my lord. So, and there was no stagnation.
Read the cadre rule. Let us see how it applies.
My lord, the
Where,
cadre rule.
where have you taken up that contention before the CAT?
So that paragraph, I have stated that
What do you want to
Lordship,
state?
see the
Where
impugned
have you
order.
taken up this contention?
Impugned order, your lordship,
No, not order. Where have you taken up this contention?
contention in the
Whether
counter
benefit of grant of benefit of ACP or RACP is dependent upon he is compulsorily joining the changed nomenclature, reorganized structure. That you have to show.
Yes, my lord.
Now show it.
My lord, your lordship, see the order by which we have rejected his application. There it was indicated at page 92. Your lordship, allow me to turn to page 92.
92.
Yes, my lord. That is the annex note which was appended to the.
That was challenged before the CAT.
Yes, my lord. Yes, 92. Letter dated 28th June 2019. Your lordship, allow me to place, my lord. This is with reference to order number such and such, my lord, the representative submitted such and such. Sri Madhavananda Lenka has requested to consider his case for grant of second financial upgradation in the pre-revised pay scale of rupees 8,000 to 13,500, grade pay of 5,400 in PB instead of grade pay of 4,800 with effect from 21/3/2007. And third financial operation under the MSCP.
No, come to reasoning part.
Yes, ma'am.
1, 2, 3.
1 to 3 is important in respective of the fact whether incumbents have been absorbed into SSF cadre or not for encadred post. Same guidelines are to be followed which are meant for SSA cadre in view of the principles prescribed by MO SPI SSS. Further, he claims that according to MO SPI SSA home dated such and such by reference number 1 and 2 respectively, made clear that second SCP will be from the pre-revised pay scale of rupees 6,500, 10,500 to the pre-revised pay scale of rupees 8,000 to 13,000.
Kindly come to 4. Para 4.
Para 4 is the concluding paragraph. First, this has been examined by the ministry and it is observed that since Sri Lanka was not absorbed into SSA cadre due to its unwillingness.
This word is bad. Where is that unwillingness? Option is given to him. When option is given,
Yes,
the element of unwillingness has no scope to apply. There are such judgments. There are such English judgments. Where you have given option to him, can it be a case of unwillingness?
But had he been accepted the option?
Where have you made it? This grant of these benefits are not made dependent upon he exercising the option in a particular way. Option is given either to join or not to join. Then how can that be a ground to deny the benefit to the citizen? Did you tell him, if you do not join, you will not get these things? Where is the indication?
Assured career progression granted in case of stagnation.
And they are saying Orissa High Court judgment. Which is that judgment?
That is the previous judgment.
Show that.
That judgment, my lord, I have not been able to.
Then how you are going to argue your matter?
My lord, that judgment is that by virtue of that judgment.
No, we do not know. I was in Karnataka.
My lord.
We do not know. Which is that judgment? You have given that reason, na?
The earlier judgment, you will not see.
Where is that judgment?
That judgment, my lord, that was filed by the writ application was filed by Union of India.
Where is, unless we see,
Bad.
how you will know? Did you appear in that matter?
No.
Then how will you know what has happened? How will you know? How will we know?
Yes. But that
You bring that judgment.
I will bring that judgment if you will not see, my lord.
Well, we got to let the request of the CGC,
No, my lord.
Senior Panel Council,
Senior panel.
Senior Panel Council, opinion for the petitioner, who undertakes to produce the judgment of this court referred to in the order that was impugned before the C18. First of all, not producing a copy thereof may result into an adverse inference being drawn against the petitioner. Yes.
Well, the whole difficulties will not content proceeding is initiated. They had
Don't precipitate the content matter.
No, well,
If-
that objection submit. My Honorable High Court's order. After that, they have passed the order in favor of me. That is annexed to the pay 68.
matter requires
6,500, my lord.
He wants to depend on
Let me
to press into service that judgment. Be kind. Do not precipitate the
No,
content.
because the date is there,
Till
but date
next
is there.
date of hearing, the content proceedings pending on the file of tribunal shall not be precipitated. Otherwise, they will face
It
problem.
will come in later on this one. This
This matter is third week of
under fresh admission.
now.
For fresh admission, otherwise
It will come in the same
68 years old man.
No, it will come in the same list. We are not admitted. Yes.
Item 4, WBC 9124
Shall we direct the registry to show your name?
Yes.
Registry to show, reflect
Yes,
the
we
name
can.
of President Council Sri so and so as representing the OP employee. Yes.
I wish to confirm your statement.
Yes.
Item 4, I have enforced wrongly, I have enforced one judgment is the tribunal judgment. Keep
You have to repair that.
repair. What next week?
Call next week to enable the counsel for the petitioner to repair the pleadings. Yes.
Item 5,
Well, week of next. Yes.
May I please, Your Lordship?
Yes.
Here, my lord, limited prayer is that section 14 application of the bank was, my lord, allowed by the collector under Annexure 1, my lord, and directing, my lord, the Tahsildar to remain present, and also requested the Superintendent Police to, my lord, accord police assistance.
Yeah.
But that was passed on 10/11/2045. Immediately, the bank requested the Superintendent Police under Annexure 2 on 19/11. But as on date, my lord, the police is not providing.
Why police is not providing who appears for the state? Mr. Sen. Ray. Police is not helping the bank. Have you seen the judgment of the apex court?
That's my direct.
Why they are coming here? Who is the jurisdictional police officer?
Jharsuguda. Superintendent Police is Jharsuguda. Jharsuguda.
SP Jharsuguda. You want him to be suspended?
No, my lord.
Or you will do that with some respect?
Copy of the
Give that.
copy of the
Give that. The short grievance of the petitioner bank is as to police not cooperating in implementing the order passed by the district collector under section 14 of the Surface Act 2002. First, it has long been settled by a category of decisions of the apex court that the authorities in general and police in particular have to render services, render aid and help, render aid and help in the implementation of section 14 order of the kind. First, learned AGA, ASC, Mr. Hon'Ble very fairly submits that he would instruct his clients, official clients, to look into the matter and provide necessary police help in the implementation of the order in question. Personal. Next one, with the above observations, matter is disposed of. Yes, registry to send a copy of this order to who is the borrower? No, it's the bank, you know. The borrower is borrower. No. Mamata, Kaushik, 5 and 6.
Yes, 5 and 6.
5 and 6. Let's speak.
May I please, Your Lordship?
Yeah.
My Lord, this case has been filed challenging the order of the tribunal by rejecting the interim prayer.
What was the challenge?
Challenge, my short case is that the petitioner is a retired person. During pendency, in course of his service, he was charge sheeted under Rule 14. Subsequently, that ended with an imposition of compulsory retirement. Subsequently, appellate authority has set aside the order of
compulsory retirement.
Set aside the order, and he was reinstated. And he has challenged before the tribunal also, because within 6 months, since appeal was not disposed of, he was challenged before this tribunal. The tribunal also held the order of compulsory retirement was. And
how many years of service you have put in? How many years of service your client has put in?
30 years, my lord. He is regularly, he is retired, so crossed the age of superannuation in 2020 during pendency. After that, my lord, court has said the pass, but liberty has been given to the respondent to do as per law, my lord. Subsequently, since he is retired, they have appointed an ad hoc disciplinary authority. Ad hoc disciplinary authority. Ad hoc disciplinary authority, because the disciplinary authority who was initially, he was not competent because he had the applicant was appointed by a higher rank, my lord. Subsequently, ad hoc disciplinary, that was under challenge before this tribunal, saying that since he has retired on superannuation, so president has the only authority who has to pass an order, my lord.
Order for constituting the inquiry.
No, already inquiry was completed. Inquiry report said that charge is not proved. Ad hoc disciplinary authority issued notice of disagreement. That was under challenge. So, my humble submission before your lordship, since he has retired.
What was the charge?
The Aadhaar card was not dispatched. properly.
Discharge it properly.
Properly,
It was
because
discharged, but properly it was not discharged.
that
Let us see the charge.
and page 39, my lord. Article number 1. Senior wife while functioning as postman Sambalpur HO with effect from 95 and entrusted with delivery of works of postman bit number 80 during surprise.
Yes, Mr. Paddy, why do you trouble? Let tribunal take a decision. Till then, don't try to keep the things in place. Don't precipitate. 30 years service. Number 1. What is the charge? What kind of charge?
Charge is not proof.
You must have filed a counter affidavit with this tribunal.
Tribunal has rejected.
I don't have any instruction in this regard.
Well, then we will issue model and notice to you. Then you appear.
What I am saying, my lord.
Yes.
Let's keep it to next week. In the meanwhile, take instruction.
But till then, you should not precipitate the man.
There is no next week.
We do not. We will give you 4 weeks if you want.
No, my lord.
Or
What I'm saying, instead of
you are not in KVA. You are not on KVA.
But because there is the interim order, it is not maintainable, man.
You are after unless we issue notice to you, you cannot represent heard learned counsel appearing for the petition. First, he vehemently argues that in the witness of the facts and circumstances, interim protection ought to have been granted by the tribunal, pending consideration of the main matter in way number
115.
115 of 2026.
First, he tells us that his client has put in a long and unblemished service of 3 decades, and that he has got a performance case for securing interim protection. First, a prima facie case is made out here. First, in the above circumstances, issue emergent notice and interim order as prayed for. Till next date of hearing. List word of Mr. Paddy, learned PhD, is requested to accept notice for official OPs. First off, emergent notice to OP number 4. Yes. Next.
My lord is fixing in date.
Huh?
My lord is
No, whenever you want to appear, you file objections. Yes.
That order has been stayed, my lord.
Huh?
The order.
Yes, we have given interim protection.
Here's the petitioner challenge.
Yeah.
The e-auction notice under Annex 7, madam. Earlier, this petitioner has approached your lordship against the irregular calculation of interest, my lord. Your lordship may turn to page 26, my lord. Your lordship's order, my lord. Para 2.
You appear for the bank? Yes, ma'am. Any relief can be granted to him?
Copy may be sought.
Yes, ma'am. Because a statement was made on 12/3 that no action has been taken against the petitioner. On that basis, your lordship has directed me to approach the DRT, my lord. Again, I have appeared the DRT. On 11/3, my lord, bank has issued a notice for recovery. Hearing has been initiated by the bank. I have appeared there. Your lordship will see.
No, again, if this notice also you can challenge, you can approach the DRT.
No, this notice has already been challenged before the DRT, my lord.
You who has challenged it?
Bank has come against 15,70,000.
This notice is challenged with the 30th of March.
Yes, ma'am.
Was the date for sell. Auction has happened.
I have to take instruction, my lord, because
give copy of the petition. Call this matter tomorrow. Yes. See, so on request accept notice for the OP bank.
In the meantime, my lord, no question next.
Already.
Because 33. Yes.
Yes.
Both the 8 and 9 are connected matters.
It's my duty to prove that Annex 1, 30, the order that was passed by the tribunal was headed by the then Acting Chairman, Shri Hon'Ble Shri V.K. Das.
In that process, my lord, will be very difficult. Because, my lord, I know that, my lord, Justice Das, from here, from the very beginning to ground for when the Ajay room was there. That is so fair. I have faith on both my lords who leader there. That is not a criteria. He is a simple thing, my lord. No, but how we can? Because I'm only apprehending my.
So it has to go before a bench in which just Honorable Justice that's it.
My lord, my lord, may I pray?
8 and 9, Your Lordship.
All are connected matters are pending.
Most these matters.
I think my lord has Justice has granted permission by with Justice MS, Honorable Justice MS, so my lord will sit, my lord.
No, but we cannot hear the matter.
No, my lord.
In this combination, we cannot.
No, that's why I'm finally remember all the connected matters to one matter they are taken together.
But these matters along with those matters, let's take them before a bench which does not comprise of Honorable Justice Pashwa.
Okay.
May I please, Your Lordship?
He was praising my brother. Yeah, I felt so happy because I learned so many things.
Actually, we did just solemnly, Your Lordship.
No, it is not like
Because I know both my lords, I know the my lord, Honorable Justice Das, and also my.
It's a pleasure to sit beside a person like him. I tell it from heart.
Really, my lord, I'm grateful to him because of his kindness, my lord.
Yes.
May I please, Your Lordship? My lord, here the petitioner is a MSME, my lord, registered under the MSME Act, my lord. Annexure 1 is the certificate of registration, my lord.
Yeah.
It is a fabrication unit, my lord. Young entrepreneur, my lord, availed a overdraft facility from the
13.4 is issued.
My lord, 13.4 without issuing 13.2, and Your Lordship under the MSME Act, my lord, if before turning into the account NPA, they have to form a committee.
Committee will certify that.
Incipient stress. They have to find out what is the difficulty and
the amount due.
My lord, I have to 52 lakhs 500 overdraft. Now the due is as per 13.4 is 52.38, my lord. So I am ready, my lord. I want to do the business, my lord. I am ready to deposit, my lord, 10 lakhs immediately, my lord.
Not that. It is 52 lakh 38,000.
My lord, yes. My overdraft.
Will be how much?
My lord, overdraft 25%. I will immediately deposit.
Well, it's 30% limit, no?
30%. Okay, I'll deposit within 2 weeks, 3 weeks, my lord.
30%, 3 weeks,
my lord.
Or
if Your Lordship desires some more time can be.
No. Precipitate the coercive proceedings are kept in abeyance, subject to petitioner depositing, crediting with the bank. 30% of the amount we demand in 3 equalized weekly installments. Payment. Not only interim protection stands rescinded, but the petition itself runs the risk of dismissal on that ground for sake.
No course of action.
Yeah, that's what.
Yeah. My lord, calling this matter
next year. First, the installment you have to pay.
My lord.
Will ascertain next year.
My lord. Okay.
Otherwise, petition stands rejected. That's what we have said.
Yes, my lord. Urgent certified. Urgent certified copy.
Oblige,
my
Lordship.
Yes.
My lord, on 31st August 2019, I requested the bank for one-time settlement for amount of 40 lakhs. It was approved. And I paid that amount, but with a little delay of 4 to 5 days. But they have cancelled my OTS, my lord, and now they are going to take possession, the process under the surface. Yes.
What is the explanation for the delay? When OTS is accepted,
my lord,
your timeline is also mandatory.
I consider my 25/9/2019 was the last date of
deposit of the entire amount.
Correct.
Because I made the offer of 40 lakh by paying 8 lakhs upfront. The remaining amount I was supposed to pay by 25/9/2019. Let's say glance to page 10, my lord. On 25/9/2019, I deposited 5 lakh because I could not arrange the amount. And rest amount I deposited on 3/10/2019 and 4/10/2019.
Is it true? No, my lord, that instruction I am not agreeing.
Yeah, now what they want to do?
My lord, now they are, instead of issuing the NOC, my lord, they are proceeding under the Surface Act, my lord. They are coming to measure the land. They are coming to make valuation of the land.
You deposit entire money with the bank first.
I have already deposited, my lord.
Entire money you deposit?
40 lakhs I have deposited.
On 3/10/2019.
My lord, 3/10/19. My lord,
14. Issued emergent notice. The learned panel counsel Sri so and so appears for OP Bank. First one. An application in IA number so and so supported by a bidding seeking interim protection against the court measures of recovery. First one. Counsel for the petitioner submits that client has already remitted entire OTS amount, albeit with a short delay. That is on 3 and 4 of October 2019. First one. The case is made up for the grant of reprieve pending litigation. First procedure ordered accordingly, and the IA is disposed of, restraining the bank from proceeding coercive measures against the petitioner. Okay.
Matter is related to 2019.
They have paid already. On 3rd and 4th of October 2019, he has already made the payment. So let us examine. The prima facie case is made out. It's not that he has not repaid at all.
My lord,
Yes.
fixing the date.
Till next date of PhD, call of the 3 weeks. 3 weeks. You have to file your objection, no? Yes.
Copy may be soft.
impossible. I'll search. Here, my lord, I have challenged the order of the learned Deputy Appellate Tribunal, which is dated 16 April 2026 at Annexure 13. Whereas, my lord, the DRT issued caused an interim order in my favor, subject to deposit of the entire outstanding, that is as per the 13-2 demand notice, my lord. I deposited, my lord, I complied the condition, the interim order was continued on that basis. That order was challenged by the bank before the Appellate Tribunal. And the Appellate Tribunal reversed that order on the ground that in view of the Bakna Motors and M. Rajendran case, the scope of redemption is not there. But my respectful submission is that
No, repeat the last sentence.
in view of the Bakna Motors case and M. Rajendran case, my lord, the scope of redemption is extinguished in view of the publication of the sale notice. That is the law, my lord.
Only after this 86, after 13th,
My
at 86.
86. After
Right of
publication of the notice, the redemption. But here, my respectful submission, my lord, my entire case is not based on redemption, my lord. In my entire surface application, I have not pleaded anywhere for redemption. I have challenged this surface application, the action of the bank on the irregularities only.
You had an advantageous interim order at the hands of the DRT.
My
That was challenged before the DRT by the bank before the DRT.
lord.
DRT reversed that.
Reverted.
Further, you appear for the bank. Yes. Would you direct the DRT to dispose of the man matter itself? Okay. Till then, I don't take any precipitate action because they have already remitted the money. Instruction was Ramasia deposited because
It is on record, my lord. I deposited over the DRT.
on record. Sir, DRT itself has said that. Just now I'm going through the order. You want time? Or you can dispose of the matter. Your lordship may dispose of directly to dispose of within 2 weeks. But in fact, it is not dispose of within 2 weeks. We both are fighting in 2 matters this year. Coercive measures initiated by the bank, the petitioner borrower had raised a list before the DRT in essay number 149 of 2025, correct? 25. First time. In the said essay, he had moved a miscellaneous. He had moved an interim. He had sought for interim protection, and the DRT had accorded one, subject to petitioner making certain payment, which admittedly is made. First one. Against the said order, the bank took the matter in appeal to the DRT, which reversed the order of interim protection granted by the DRT, eventually resulting into filing of this petition. First one. Next paragraph. Look at the panel counsel on request appearing for the OPs, although initially opposed the petition very vehemently, now agreeable with the suggestion of this court that the interim protection as accorded by the DRT be continued and the DRT itself be directed to dispose of the subject essay in a time-bound manner at the earliest. First up. With this proposal, counsel for the petitioner is also agreeable. My proposal may not be, your lordship may direct, but it should not be my proposal. That will be great, because I have not received the copy. Here it from the order I have seen that he has disposed 20 lakhs. It has been no.
Approved the 22 lakhs already.
Opposite the petition.
24 lakhs, 48 lakhs.
No, that's opposite. Next. Having heard learned counsel for the parties and having perused the petition papers, more particularly the compliance payment which the petitioner has made in lakhs of rupees, we are of the considered opinion that the impugned order of the DRT be set aside with a request to the DRT to hear and dispose of the essay on a war footing, keeping open all contentions of the parties. First, in the above circumstances, this petition succeeds and a writ of certiorari issues quashing the DRT order dated.
Order dated 16 April 2026.
In miscellaneous appeal number, entered in miscellaneous appeal number 90 of 2025. Semicolon. The DRT is requested to hear and dispose of essay number 149 of 2025. Preferably within an outer limit of 3 months. First, all contentions of the parties. Only one line may be positively. That will remove that preferably. We will have some arrangement. Neither your word nor our word. No cost.
My lord, I will own prayer, my lord. Your lordship may direct to DRT for disposal of the original application, where I am on opposite party.
No, original application means you are banned.
No, my lord, I am opposite party.
My lord, I am
Why is 389?
My lord.
389.
My lord.
For whom?
I am from the bank, my lord.
Oh, you have public.
My lord, because of his non-appearance in the DRT, the matter is being dragged. So that's why the presiding officer is not able to pass the order. I am just showing, my lord.
No, we will tell the presiding officer to dispose of them.
Dispose of, but he should appear. He is not appearing.
We take advantage of it. Petition prayer is coined as under. Come on. Learned panel counsel appearing for the OP Bank points out that it is because of the conduct of non-appearance of the borrower, The TRAT is not in a position to try and dispose of the dispose of OA number 389 of 2019, depending on its file. First, having heard learned counsel for the parties and having perused the petition papers, we are inclined to request the DRAT to hear and dispose of the subject OA within an outer limit of 4 months.
2 months.
2 months. All these days you did not go before the
I will appear, my lord. As per my undertaking.
In as much as right to speedy remedy is one of the facets of Article 21 of the Constitution of India, in the light of a catena of decisions of the apex court of the country. First, ordered accordingly, and WP is this one of keeping open all contentions of the parties. Next.
214,
Yes.
In this petitioner challenge the order of the Central Regulatory Tribunal Court Bench in not granting the relief in shape of restitutionary claim. Restitution. The petitioner, by virtue of an interim order, her appointment was stalled about 8 years. And after disposal of the OA, the petitioner was appointed from the date of declaration of the result, which was kept in sealed cover. By virtue of an interim order, the result of the selection was kept in sealed cover. And it was opened in the year 2012. And it was opened in the 2022 by after disposal of the OA and subsequent writ petition. The petitioner is claiming for grant of antedating appointment from the date of keeping the result as sealed cover with national benefit valid. The tribunal proceeded as if the petitioner claiming antedate seniority, though she entered into the cadre in the 2002. That is the
so during the pendency, during the continuation of sealed cover, she could not secure promotion.
Promotional appointment through departmental competitive exemption.
That's what. It's a promotion only.
And
that promotion she could not. He could not secure.
So she discharged that post. Only single post in the office, and in absence of the regular employee, she manned the post. But she could not get the benefit because of the interim order and continuance of the 10 years litigation.
Why is she manager? She should have womaned the post.
Managed the post, sir.
Now there is very lot of gender sensitivity. We have to change so many things. Always in English, I used to say a reasonable man in the street. Now you can't say a reasonable person in the street now, because it should be gender neutral.
Sometimes.
So what do you say? Is it true that she has been discharging the duties in the post to which
she was joining agent 21/12/2022, not 12. She is claiming that because I was joined, I was working on 2012 onwards. Even though my joining letter was given on 2002, I am entitled to get seniority on 2012. This was the case because that's why the tribunal.
Take notice.
That is the misunderstanding of the tribunal, sir.
No.
The tribunal might claim on the basis of claim.
Order has been regularized. Joining letter was issued on 2022. It is indirectly a third round litigation before this court. This other side has come to the tribunal, then up to the High Court, then High Court passed the order.
Why she should suffer?
But no, our claim cannot be taken into consideration because above to that others are there.
No. That is not the way. Only one candidate in the selection process.
One post and one candidate.
One candidate in the selection process. The candidate who filed the way declared eligible and she has not filed the way.
Mr. Padi, to take notice, matter is covered by that Pela Banerjee matter. That find out that High Court and identical matter came to be affirmed by the apex court. Issued emergent notice. Learned DST, Mr. Padi, assisted by so and so on request of notice for all office. Matter lies in a narrow compass, therefore post it immediately after summer vacation. Yes. Yes.
Actually, bank is proceeding. Because the petitioner has defaulted in paying the installments of the loan amount, bank is proceeding. Vacation notice has been issued on the annex form. Immediately, I have filed a petition before the application before the bank to settle the account, and immediately I have deposited 3.5 lakhs 3 days back. And my instruction is that today or by tomorrow, I will deposit 1.5 more.
You are from the bank.
I have got instruction for it.
This is 24,56,950.
As of today, my lord, my instruction outstanding is 26 lakhs 46,000, my lord.
So it's 25 lakhs.
26 lakhs 48,000. 26 lakhs 48,046. As of
today.
As of 15 April, man. 15 April 26.
He wants to pay now. You don't want payment.
Let him pay, man. I am not saying that because I have already filed a recovery proceeding.
6
The matter 6 to last week. Well, I have filed a recovery proceeding before the DRT. It was noticed and it was fixed to last week for appearance. It didn't appear. Though the notice was sufficient, it didn't appear.
Way number?
Way number, my lord. Way number 115 of 26. 115 of 26.
Now, if he makes the payment.
Let him pay, my lord.
Huh?
Let him pay, my lord. I am not on the way, but you have to pay a substantial amount, my lord. Because he has not paid anything.
Why can't you speak? What has happened to you? He is speaking something sensible. You are interrupting it insensibly. Substantial amount means how much?
26 lakhs, let him pay, my lord. 10 lakhs at least.
How will you speak? What do you say about the proposal?
First installment, then, my lord, as your lordship will fix.
And some time, 3.5 lakhs, 3.5 I have already deposited 3 days back. And another 2 lakhs I will deposit by tomorrow. Your lordship may grant me some time to pay the.
Now it is 26 lakh 48.
My lord. But my instruction, my lord, today, he has not paid anything.
Nothing.
This is my instruction. I do not know.
Show it to your friend. All right, we can show it to us. If he says it is paid, then
just 2 days back.
After filing of the petition or before?
After filing the read petition also.
After filing the petition. You have paid 3.5 lakh.
3.5 and by tomorrow I will pay 2 lakhs and another 2 lakhs.
So that will be 5.5. For rest of them, how you will pay?
That was grant me 6 months time. 6 months time to pay.
6 months?
Entire to settle that.
And if you do not pay within 6 months, what should happen? Again, bank will not process that way.
They will proceed.
Proceed means?
6 months.
You want extraordinary jurisdiction, invocation, you are invoking extraordinary jurisdiction of the court when OA is pending there. Is it not?
They will settle the account.
You pay that entire money within 3 months. Till then, that OA will keep OA will be kept in cold storage, as many OAs are now already.
My lord. Next date is 9th of June also. I will not proceed with that.
And Exor 5 is pending with the bank. You not direct them to negotiate. And Exor 5 is pending with the bank. Bank may consider it.
Yes, it is. For settlement.
Yes.
No, you are asking for 5 to 6 installment. 5-6 months.
Months.
5-6 months. That also, yes. Brother, he has sought for 5-6 months installments. And suppose if it is 6 installments, how much it will be? 26.48 plus that amount that will increase. Even if it is taken as 27.28. 28 divided by 6.
I think 27 lakhs.
Every month you pay 5 lakh.
Every month.
Every month. According to you only.
The file
That's
that-
what
the
the
file-
prayer is,
the
even
file-
in the reciting.
Yes, ma'am. That will be fair enough. A copy of requisition may be sought.
You give custom.
In course of it. In course of it. Yes.
Shorn of the text of the prayer in the petition, the essential grievance is as to non-consideration of petitioner borrower's representation dated 24/4/2026, a copy whereof avails at Annexure 5, wherein he has sought for a period of 5 to 6 months for settling the entire loan amount. Which is stated to be now 26 lakh, 26.5 lakh. About 26.5 lakh. First. Learned panel counsel appearing for the OP bank opposed the petition contending against its maintainability, and when his client's OA number 115 of 2026 is pending on the file of the Cuttack DR. First up. Next paragraph. Having heard the counsel for the parties and having perused the petition paper, we agree with the proposal of learned counsel for the petitioner that his client would remit the entire amount within a period of 6 months on equalized monthly installment basis. First off, he has shown the bona fide by remitting a sum of rupees 3.5 lakh, which is vouched by waiving the remittance voucher, which is shown to learned counsel appearing for the bank as well. First off. Further, he says that the petitioner would remit another sum of rupees 2 lakh within 1 week. Within 1 week. First off. There is a reasonable bona fide exhibited by the conduct of the petitioner, coupled with assurance as well. First off. In the above circumstances, this petition is disposed of with the following directions. 1. Petitioner shall repay the entire loan amount with account number, see page 16, an example. That's fine. And that account number is written. Account numbers, so and so, so and so. They are written down. Fine. So within a period of 6 months, by remitting equalized monthly installment on or before 5th day of every calendar month. Number 2, non-payment of one single installment would entitle the OP bank to take the coercive measure under the provisions of Surface Act 2002, disregard of pendency of OA number 115 of 2026. Three, petitioner shall remit a sum of rupees 2 lakh within 1 week from this day, as has been undertaken above. First, ordered accordingly. That's all.
A copy of the requisition is sought.
Give that copy.
Yes.
Well, in the meantime, of course,
In the meanwhile, the OA number 115 of 26 shall be kept in abeyance, subject to compliances.
Annex of 4 is vacation notice. Annex of 4.
So also, all coercive proceedings are applicable. Okay. All other coercive proceedings are applicable. Yes, copy, man.
May I please, my lord? So, interport date of report by the petitioner challenging the order dated 6/9/2024 was in case number 15129.
Challenged in the WPC.
My lord, only my request is dismissed only on the ground of lack of territorial jurisdiction.
Now, what was challenged then?
What was challenge?
What was your complaint before the learned
My lord,
judge?
order of punishment. My removal from service passed by the Disciplinary authority. I prefer appeal. Appeal dismissed. Then revision.
Removal date is?
Removal date is 18/5/2020, 15 miles, 2015. 18/5/2015. Annex of 3, page 18, miles.
18/5/2015. And appeal order?
Appeal order 10/8/2015, miles.
Revision order?
7 January 2016, my lord.
Where is the place of working?
Jammu, my lord.
Jammu.
Yes.
Jammu Kashmir. And appellate authority?
Jammu.
Revisional authority?
Jammu.
In this case, after order of removal, I prefer my appeal from Jammu. Then I left from Jammu and remain in my native place at Andhra, Keonjhar, Odisha.
Suppose you go back to Chennai. Can you file writ petition in Chennai on the ground of your residence?
My lord, I have relied upon three decisions, my lord. In one case, my lord was appearing.
Let us see. Either respondent should be within the jurisdiction of the court. Any part of the cause of action should accrue within the jurisdictional limits of this court.
My lord,
A part of statute should say, for example, where the lady resides under a family court.
Part of cause of action arranged with the state of Odisha, my lord.
Where?
By receiving appellate order, reviewing order, and mercy appeal order, my lord.
So when you receive the cause of action, not like
That is the law decided.
Is it?
My lord.
That's the place to be restrained.
Case of no, I also concede part of because it is on the record. Supreme Court 2013 scale, the Novelkar judgment, the Supreme Court say once the communication, the order to the particular place with the place of cause of
action.
Yes. Basically, that my friend is alleging this. But thereafter, many decision is coming and said that
another that's virtually up to giving jurisdiction, making the jurisdiction dependent upon the postman.
Oh, yes. It is. By this judgment,
No, but let the single judge decide then.
But only single judge rejected this case for the
Lack of jurisdiction.
So
now you already see your judgments wherein you have appeared.
So what I'm saying, my lord, I just give me some time. I'll examine that decision.
Judge notice. Learned DSG, Mr. Body, on request accepts notice for the office. First, matter lies in a very narrow compass, not immediate application, summarization. Obliged. Next.
Along with Mr. Kashyap is appearing in the lines.
May I please, Your Lordship? In this case, the bank has already appeared and the borrower has also appeared. The case is like this, just a brief. borrower has taken some loan, defaulted, NPA was there.
You are the bank.
I am the auction purchaser.
Auction bank.
My lord, I took part in the auction purchase, and I was the highest bidder, and the amount of settled, I have deposited the entire auction amount, 2,85,000. Then I approached the bank to deliver person. Bank was not giving deliver person. In the meantime, what happened? Without impeding me, the borrower has filed a petition before this Hon'Ble Court. Then in that case, notice was issued. The bank appeared in presence of bank. Bank has not disclosed that the entire amount has been deposited. Therefore, this Hon'Ble Court directed some amount be deposited by the borrower, and bank will consider the witness. Thereafter, bank was filed another IA in that petition, stating that 25% of the auction purchase amount has been deposited by the auction purchaser. Then in second point also, they have suppressed the fact that I have deposited the entire auction amount of 2,85,000.
Not 25%.
Not 25%. 25% and entire amount have been deposited. Then this Hon'Ble Court directed that the amount 25% may be returned to the auction purchaser. I was going on approaching. Thereafter, bank told that no, this order has passed by the Hon'Ble High Court, you go on approach. Thereafter, I filed the petition number 1573 of 2013 to set aside the order passed by the imbue of the
Shivdev Singh versus
judgment. Another case in Hamza Ali. Wait 1 minute. Hamza Ali and State of Kerala. Either I can file a review petition, I can file a petition to pass. Then this Hon'Ble Court, by annexity, gave me was pleased to give me liberty to file review petition. Said that this is a coordinate bench has passed on, I file a review petition so that it will be better part to deal with. Thereafter, I filed this review petition. So only compulsory is that this order has been passed by the Hon'Ble Court because of suppression of fact by the bank.
If the bank had said full payment is made, this judgment perhaps
this was obtained by
the entire money is given back to you.
No, money has not given.
Money is also not given back to them.
I filed with petition. I filed with petition. So this is the status.
There is also delay. That also that's 394 says delays matter. First he has not.
He was not a party.
I am not the bank manager.
Correct, but he was not a party to the petition.
Yes,
you did not take up the contention that already the buyer, auction buyer is there. Let him be impeded. That is not your contention.
Let's go to the order sheet pass for this on the court match.
No, we are asking you. Did you tell the coordinate bench already properly we have auction? And Mr. X, the review petitioner, has being the highest bidder, has remitted so much money. And therefore, did we impeded? Did you tell the bench?
Yes, my lord. It's the matter of 212. No, my lord. Your lordship,
you are not answering. You don't want to answer the point.
Yes, my lord. I answer. That also not reflected in the order sheet, my lord.
Where did you say? Where is your objection? Did you file objection?
No, my lord. That time it is a matter of 212, my lord. That time we have not objected a fresh addition. This Hon'Ble Court, the case disposal fresh addition, my lord. So that is not that time. This is not a position to file of any counter after.
No, not fresh addition.
Yes.
After issuing notice. In that case, after issuing notice.
Yes, you go to the order sheet.
Yes.
Page 90.
Admission stage it is allowed.
Yes.
Or after post notice it is allowed.
After notice was issued,
1970.
Yes. That is lordship page 17. I am reading that. Hard learned counsel for the petitioner and see Ratha learned counsel appearing for the after notice was issued.
Yes. My lord, it is petition filed by the lonely my lord. So my lord, I have also appeared recently. I have a small counter. So 2 times to granted, 2 times to file counter. That also matter of this much. Also, the lonely has been not appeared in this matter.
No, lonely has entered appearance. Avoid background one.
And he has also filed the review petition in this matter.
He also filed a review petition.
Who has filed? You have filed the review petition.
I have filed the review petition. What?
Yes, sir.
So that order was passed in presence of today.
Yes, sir.
Dr. Rocker.
Yes, sir. Yes, 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 sir. Yes, sir.
Not deposited the balance.
You have said he has not deposited the balance amount.
This was on 19/7/2012.
My lord.
On that date, had you remitted the entire money?
Yes, my lord. That I have said, my lord. On 12/3.
Why did you mislead that?
Yes, I have stated, my lord.
Let's go to the.
Did it on which date you have paid that?
I have deposited, my lord.
You have deposited 25% when?
25%.
Remainder when?
So in 14/3/2024, my lord, I have deposited 25%.
24.
I'm sorry, 12. I'm sorry. 12, my lord.
14?
14/3/2012, 12, my lord.
Entire money you have deposited?
No. I have deposited 46,250.
How much it is? Will be
This is 25% of the auction amount.
And remaining amount is paid out.
Prior to that, Lord, I have deposited 25,000. That was earnest money. 71,000 total I deposited, Lord. Thereafter, Lord, on 21/3/2012, Lord, the auction was, the sale was confirmed, Lord. Then 21/3/2012, Lord, March 21st, Lord, I deposited balance 2,10,750.
Total amount.
So in total, it was 2,85,000.
21/3/2012, you remitted entire
Balance 2 lakh.
So as on 19/7/2012, when the
I have deposited the entire.
you had paid entire. But they have told the bank told the bench,
yes,
you have not paid entire money.
On this occasion, Lord, on the first case, there the bank has filed a IA that the amount has been 25% has been deposited. That also they have in the second IA, Lord, that has also they have not disclosed that the entire amount has been deposited. That you Lordship may kindly see. The next.
Where is the borrower now?
Borrower has appeared, Lord. Mr. Chinchani. Petrol one.
Interested in the matter. All right, now let us, we will not trouble the borrower. What is the compensation you are paying?
Yes,
I just small counter. I recently appeared in this matter, madam.
When notice was ordered to you?
I appeared in 6/4/2026, madam.
No, when you appear is irrelevant to us. When notice was ordered? When notice was ordered?
There is delay, madam. Before the petition, madam.
We'll condone the delay, 90 days.
No, madam. 393 days. 393, 360.
But it was not a party.
Madam, yes, you also put a review. They have filed a review, my lord.
Correct.
The first case, my lord.
Yes, means?
All document also is not here, my lord. That also, for that, my friend give me all documents for that also.
No, he was not a party at all. If he were to be a party, then limitation of 30 days. If he is not a party, there are two views. From the date of knowledge, 30 days. Another view is court should condone the delay. Because he is not a party. He will not know what happened behind his back. Especially when you have defrauded the court. And you have defrauded the review petitioner also. When he has paid entire money as on 21 March 2012, who took up a contention before the court, even in your application, that he has deposited only 25% of the money. That is a fraud on the auction buyers. Fraud on the court also, because you have matched that order by misleading the court.
First, the money has come to this court, madam.
Correct. But there you should have taken up a contention. Yes, we had auctioned the property. Mr. X has bought that property. He has remitted entire money. Now you cannot send him back empty-handed.
Pay one time to.
No, but delay we shall condone. Review petition is filed after proving a delay of 393 days. First, the petition is accompanied by an application supported an affidavit seeking its condonation. First, learned counsel for the review petitioner vehemently submits that he was not a party to the subject case, that is WPC number 4796 of 2012, which has been since disposed of on 19/7/2012. He being not a party, he is a nominee. First one, a plausible explanation is also offered. First one, no objection is filed to the said IA till date. First one. Now, learned panel counsel appearing for the bank seeks accommodation for filing one, but we do not agree with that proposal. There being no explanation as to why no objections are filed till date. First one. Next one. The apex court in P. Changalavaraya Naidu versus so and so has held that an order obtained by fraud is not and that such an order can be put in challenge before any authority at any time in any proceeding, even collateral. First, if that logic is obtained, there shall be no delay at all to moving the review petition. First. Secondly, the it is on record that the review petitioner was not arrayed as a party to the subject writ petition. First, records do not reveal that the bank had made any effort to bring to the notice of the coordinate bench which decided the said WP that the review petitioner had remitted entire auction price on 21/3/2000 as on 21/3/2012. First, ordered accordingly, and application is allowed, and as a consequence, delay stands condoned. Call this matter immediately after vacation. Vacation. Okay. Let it come after vacation.
One thing, Lord. I have filed immediately thereafter petition, Miller. My Annexure 6, this Hon'Ble Court was given me liberty, Annexure 6.
The records reveal that the review petitioner had filed a WPC number
1573 of
2013, which was eventually disposed of
on 21st June.
Liberty as drawn with the
Liberty.
disposed of as withdrawn with liberty to file the review petition, presumably keeping in view the 5-bench decision of apex court in Shudev Singh versus so and so 65. Yes, 65, 64, 65 Supreme Court. Okay, that also. The worthy cause cannot be thrown away when justice is apparently due to the review petitioner only on the arguable ground of feeling.
May I pray one thing? This is small matter only. The residential house, I don't have. Is my neighbor, Milan. I took part in the auction, Milan. I was scolded by my neighbor, Milan. Lordship can imagine, Milan, because I am the immediate neighbor, Milan. Bank has harassed me. Only point that residential house, Your Lordship, that also I agree, Milan. Only I should be compensated. That is my only, because of harassment by the bank, Milan, I should be compensated. That is the sole question. So can it be taken up before vacation? Before
vacation, we have difficulty. Come fresh after enjoying the vacation.
Fiction date, Milan. Fiction date should
immediately after vacation. Yes.
which has been rendered by this Hon'Ble Court.
Delay of how many days?
Your my lord, delay is 111.
This intra-court appeal by the state. This is covered by Krishna Chandra Malik.
By Krishna Chandra Malik. That judgment I have.
In fact, identical order. In 11 days. Only 18. Only 180.
Another item 13.
30.
30. Right.
30 also. How many days? Just close. Before finally the practice. So it's the same. Yes.
Item 19, we have the application of 2024.
Item 19, my lord. It's a state appeal challenging the order passed on 4/9/2023, my lord. May I submit the few facts, my lord, backdrop of the case?
Yeah.
The petitioner was appointed, the respondent number 1, my lord.
What was decided in SP Das case?
Exactly. SP Das, they are claiming that SP Das and these two petitioners, the present petitioner and another person, they are in the same footing, my lord. But in that case, my lord, this has been so far the original application is concerned, which was referred to this Hon'Ble High Court after closure of the tribunal. Their order has been passed in his favor. But so far this present case is concerned, this present petitioner was filed number 593 of 2008. It was dismissed on 8/1/2010.
By the tribunal.
Yes. Challenging the same, the petitioner filed writ application before this Hon'Ble Court.
Writ petition number
16921 of 2010.
That what happened to that?
That was also dismissed.
On?
It was dismissed on 24/1/2019. May I supply the copy of this one because this is not available.
Give that. A considered order.
Yes, division bench. Finally, it was dismissed. Execution it has been passed. This was disposed upon 24/1/2019. It was dismissed. Confirming the order of the State Administrative Tribunal, which was passed in 593 of 2008. Then waiting for around more than 3 years. Once again, another writ application was filed on 25524 of 2022.
25524
of 2022.
$255,000.
No.
25,000.
WPC 25,524
of 22.
Of 22.
But these orders, nothing was mentioned.
This order has not been challenged. So far, this
This
division bench order.
6921
Exactly.
has not been challenged.
4/1/2019, this has not been challenged, madam.
Identical cause of action. Same cause of action.
Yes, ma'am. Same cause of action, same petitioner, same order. After lapse of 3 years, madam, this writ application was filed 25524 of 2022.
What was the grievance in WPs in OA 593 of 2008?
Yes, madam. That has been taken care of in this order, madam, and at a glance. The relevant portion of the order at page 2 of the judgment.
Which judgment?
Yes, ma'am. That has been quoted in para 3. Rabindranath Panda, son of such and such, temporarily appointed as a peon in the existing vacancy for a period of 89 days or till regular appointment is made by the collector Ganjam, which is earlier. And then skipping the last part is Mr. Panda such and such belongs to general category and now working on an ad hoc basis is hereby temporarily appointed as a messenger against vacant post in the scale of pay such and such with usual day and other allowances as admissible by the government from time to time. The appointment is purely...
It was a case for a disengagement.
Disengagement.
And here in the subsequent 25524 of 22, what was challenged?
This was a representation they have filed for consideration that was kept pending with the authority even after the division bench. This has not been accepted. So their consideration of the representation. That was the order.
For regulation.
Consider regulation. It cannot be regularized. It can be reinstated in service. Cannot be regularized.
Reinstatement
so that was the order dated 28/9/2022.
So was it terminated at any point? There is a disengagement order.
Yes, Miller. That was 31st May 2007. Miller.
Yeah. 31/5/2007.
On 31/5/2007, you were disengaged.
Well,
Yes. Thereafter, you filed OA 593.
yes,
That was dismissed.
my lords.
W16921 dismissed on 24/1/2019.
Yes,
Thereafter, you made a representation seeking your reinstatement.
I'll come to that, my lords. Why I have done it. If I may.
Wait, let him complete.
So, this writ application, so far the consideration of representation is concerned, that was the order was passed on 28/9/2022 for consideration of the representation.
28/9/2022. Representation dated?
The representation dated, but it was rejected on 23/5/2023. The representation is my lord.
Rejected on?
This was rejected on 23 May 2023.
Against this, the subject petition was filed, from which your impugned order.
Yes, exactly.
That came to be allowed, WPC.
Yes, my lord.
That WPC.
This WPC number is 26558. Millard and 25524.
Representation was considered. Yes.
Representation was to be considered.
And it was
Then that representation was considered and dismissed.
23/5/23.
Against that order, 26558 was filed. This was disposed upon 4/9/2023. Out of which this present writ appeal was raised.
Because they directed reinstatement.
Yes, my lord. The operating part, my lord. May I invite, my lord, it pays 22. On the first day, my lord, even without hearing and we have not been given a chance to file the counter, it was quashed, my lord. The order
So,
way back in the year 2007, which was passed.
You said something. Yes, what happened? You were not here.
No. Well, at the first date, can have a glance to date 4/9/2023 at page 17.
23. That is the order part.
That was the order passed, which is the impugned order in the writ appeal.
Right. What the order says?
The operating part of the order is page 22.
But they say that third.
There in my lord.
No,
Here, my lord, counter has not been filed, man.
No, what is that order?
Yes, my lord. 22, my lord.
What examination?
Page 22.
Opinion. SP Das gives.
SP Das.
Whether SP Das should also removed that way.
SP Das was removed.
The similar way.
Similar one.
And
they are against the existing vacancy. And by virtue of the Hon'Ble Court's order, he has been reinstated.
No, which order? In tribunal.
That SP.
Yes,
Of course, tribunal, then after closure, it was handed back to the High Court. Then in that case, they have been reinstated. So the petitioner's case is concerned, that has been dismissed before the tribunal. Subsequently came up in the division bench. Division bench has also upheld the judgment of this tribunal. That has not been challenged by the petitioner. Subsequently, when that matter is stood like this, then after 3 years filing a representation, then the writ application.
Let us see what your friend will say.
Well, it's grateful. That I just want to place one thing, that it is said that state is not an ordinary citizen but a mighty litigant, and they have all the means and modes that they can fight the end of the day. But in the present case, he is a poor man, and therefore the state should conduct itself as a virtuous and a model litigant, is what the Lordship has held and Honorable Supreme Court has also held. Starting with that, I want to point out,
we have
a limitation point. This is my first submission. Then I'll do the merit. First submission is on the point of limitation. My lords may see the conduct, there is a delay of 202 days. After, my lords, we have filed the contempt application, it was disposed of, then they have decided to file the present writ appeal. Did not pursue it. Back in the year 2024. My lords.
We will not spend so much time on this.
My lords.
Now, you did not disclose you were offering an order at the hands of the OAT in OA 590/2008. Did you disclose?
My lords, I'm just
telling what. Yes or no?
Yes.
Don't waste time.
We have disclosed, my lords.
Did you disclose a writ petition order?
Everything has been disclosed.
Show that in your representation.
That representation, perhaps, my lords, I do not have it on record. My lords, I do not have it right now.
Did you disclose in your WP before the learned single judge that earlier happened?
Yes.
Where is that?
My lords, in the order of the Honorable Single Judge, my lords, in writ petition number 26558 of 2023, it has been brought into record, my lords. 26558 of 2020 order, my lords.
Where is that?
Page 17 of the writ appeal.
Page 17.
17. In the second page, the following page, page number 18, at the bottom. I'm just reading out from this. It is submitted by the learned counsel of the petitioner that the said OA was dismissed, and thereafter the petitioner preferred a writ application bearing number so and so was also dismissed, thereby confirming the order passed by the learned tribunal. Let's. What I submit here. Balance.
Where is the consideration of this by the learned single judge?
Beg your pardon, my lords.
Where is the consideration
My lords.
by the learned single judge? Your disengagement order being challenged by before that OAT dismissing your application, that dismissal being affirmed by the division bench in your writ petition. So the grounds on which you have been disengaged have received imprimatur at the hands of the coordinate bench. What was the new thing for seeking reinstatement?
I'm grateful, my lords. Now, what has happened here is the relevant point. Subsequently, what has happened to the after the decision was passed by the Hon'Ble division bench, that this person, this other litigant, who is at the exact same footing, similarly, my lords, placed, he filed a writ petition, and that was, my lords, allowed, and he was permitted to be reinstated. The state did not utter a single word regarding this decision that was passed against us. And they, my lords, conceded to it, and not just conceded, but acted upon it, and they reinstated. They allowed, permitted to be reinstated. Thereby causing, my lords.
Had they suffered dismissal order at the hands of the OAT?
No.
Like you?
Yes. OAT, but no, not dismissal order. So basically at that point of time, State Administrative Tribunal was abolished. So it was transferred to this Hon'Ble court. There it was decided, and he was...
In that order,
my lords,
whether your judgments were taken note of? No.
No, it was not disclosed. That is the thing, my lords. They did not disclose it, and thereafter they have acted on it, and they permitted this other litigant to be reinstated, who is standing on the exact same footing. Thereby, my lords, giving birth to a new cause of action, where Article 14 has been clearly violated, both the limbs. Then we have filed this writ petition, my lords, to say that kindly consider our representation in view of that SP Das judgment, my lords. That was, my lords, allowed. We gave a representation. That was rejected.
In your representation, did you disclose? Earlier, I went to OAT and OAT dismissed.
Yes, my lords, that has been, my lords, I do not have the representation right now on record, but that has been discussed, my lords, in the Hon'Ble single judge bench.
No, where is it in your representation? This virtually amounts to reversing the division bench judgment of the court.
Exactly. My lords, here, my lords, the problem is that here a new cause of action arose when subsequently they have, my lords.
You can't say that because they did not approach, unlike you, the OAT. They did not approach the division bench.
They approached, that was abolished. Since Administrative Tribunal was abolished, it was transferred to High Court. Then it was renumbered. Then it was decided.
But that did not take note of your judgments.
Because they did not disclose it, my lords.
That's all. Anyway,
and they did not even challenge it later on.
Anyway, the question is not my lords. There is an element of res judicata.
Yes.
There is an element of res judicata.
Yes.
Merely because some other case who was similarly circumstanced like this, you should have sought for review of this judgment. Saying this. Yes.
Yes.
You should have sought for review of this judgment, saying that in identical matter it will happen like this. Therefore, recall this order, grant me the same relief. Otherwise, that we can see, res judicata is a grand principle. Even in ancient India, we used to call it as Purva Nirnaya Siddhanta, which Gautama Sutra mentions, Shukraniti mentions. Purva Nirnaya Siddhanta is applicable in all over the globe in different forms. It is not that some English people have invented res judicata. The Latin people, Roman Empire invented all that. We had that long, long ago. Therefore, you can't say that. And where is the consideration by the learned single state? He only says the mentions about the word. Where is the discussion?
Well, it's
show that discussion. Except lip service, nothing.
Well, it's I'm showing. Here, my lords, what I beg to submit. My lords, your lordship is absolutely correct. My lords, res judicata principle is definitely hitting here. But how our situation is different is that res judicata should be with regards to same parties with same cause of action, my lords. But here, a new cause of action took birth.
I don't agree with that idea of new cause of action at all. Res judicata enacted in section 11 of CPC. Section 11 is not the complete repository of the doctrine of res judicata. Limited res judicata is introduced in section 11. Limits are expanded in 1976 amendment only for the purpose of resisting the suit. In other words, you can't resist a suit on the ground of res judicata which does not fit into the parameters of section 11 under the 1908 Act, expanded parameters under the 1976 amendment. But for late jurisdiction, it is a bit different.
Well, so I'm just reading out the relevant paragraph of the Honorable Single Judgment.
Only 2 lines. That is
Only 2 lines. There's nothing here.
Well, here it is written in page number 21. Moreover, the benefits accruing to the above SP Das, this court analyzed both the petition and the above SP Das is in an identical footing thereafter. Therefore,
on parity.
Yes.
Parity is not the rule where res judicata comes in. Res judicata excludes the parity argument. The idea of res judicata is there should be a finality to the litigation. Finality is far better than justice is the underlying principle.
Well,
that's how courts have said. In fact, Forsyth, Wade and Forsyth in their administrative law so beautifully discussed about res judicata. Beautifully discussed. There's a famous judgment of res judicata, the first judgment of Indian court in 1800 odd. It was written by Sir Chimanral Settleward, father of MC Settleward, was the first Attorney General of the country. His father wrote a judgment on res judicata. That's considered to be one of the classics which res judicata in cities is a bit different from res judicata operating outside cities. It has spread over, spills over section 11. So that is attracted in great jurisdiction. There are such judgments. I need not immediately, I'm not able to fish it out from my memory pond, which is very small and dry, but there are judgments. There are judgments.
Well, I need to examine this point which your lordship is saying. This point, let this matter be taken up tomorrow.
Yes. Otherwise, we would have granted. Wherever we are duty bound to do justice, and all our circus is to do justice, our language, and other tactics, is to do justice. But this is a case where we cannot, we are helpless. We are helpless. We sympathize. But sympathy is one thing. Justice is another, because we take both to do justice according to law, not justice of some Mughal from Babur to Aurangzeb. That justice we cannot. We have to do justice in accordance with law. Hey, we consider your contentions. You argued
only that limitation part also, because they are not even explained anything in the limitation petition. Only that same thing.
That's also are one of the factors in condoning bill 86 opinion. The main matter has got merits is also a factor. Although some divergent views are also there, some judgments which say we need not go to merits at all. First, you should ask the limitation at the threshold. Such judgments are also there. That's take note. Can you be seated? Something. Yes. This interpretation by the state and its functionaries seeks to lay a challenge to a learned single judge's order dated 4/9/2023, whereby respondent employees WPC number 26558 of 2023, having been favored A writ of mandamus has been issued for his reinstatement in service as before. First, an application supported by an affidavit in IA number so and so is moved, seeking a condonation of delay of 221 days.
202 days.
202 days. Brooked in filing the subject appeal. First of all, when notice was issued to you?
Notice was issued in writ appeal in Manoj. January 2026, exact date is 7/1/2026.
On 7/1/26, the coordinate bench of this court had directed issuance of notice to the respondent employee who has not chosen to file objection to the said item. First of all, a perusal of the application and the affidavit in the totality of the circumstances of the main case as well would show that there is a plausible explanation for the delay proved. First one, throwing away a worthy cause on merits to injustice, if that is done only on the ground of delay in a matter like this. First, justice of the case eminently warrants condonation of the first. In view of that, we have allowed the application and delay stands accordingly condoned. First. Next, after service of notice, the respondent employee, having entered appearance to his own self, vehemently opposes the appeal, making submission in justification of the impugned order and the reasoning on which, the reasons on which it has been structured. First off. Next paragraph. Having heard the counsel for the parties and having perused the appeal papers, were inclined to grant interference in the matter for the following reasons. Next, A, B, C, D. A. Respondent employee was disengaged by order dated 31/5/2007. First, that he had put in challenge in OA number 593 of 2008 that came to be turned down by the Orissa, by the tribunal by the order dated 8/2010. First, said order being challenged before the coordinate bench of this court, she is a WP 16921 of 2010 came to be dismissed by the order dated 24/1/2019. First, the bench, by a well-considered order running into 12 pages, has given elaborate reason as to why disengagement of the respondent was justified. First, there being no further challenge, the said order has attained finality, and that is how the doctrine of res judicata, which is vociferously argued by the State Counsel, Mr. Mohanty, becomes invocable. Next point, which aspect we will discuss with more infra. Next, in WPC 3314 of 2018, one Mr. S.P. Dash had secured an order of reinstatement, which was made the basis for a respondent employee to seek the similar relief at the hands of the appellants. on the ground of parity. First of all. Accordingly, he had made a representation on do you have a representation dating? Come on. That came to be rejected on 23/5/2023. First, the said rejection was challenged by him in WPC 26558 of 2023 that came to be allowed by the impugned order hearing. The impugned order, except making lip service to the coordinate bench order dated 28/9/2022, 16921 of 2010, dismissed on 24/1/2019, does not give any jurisprudential reason how that order would seal the fate of respondent. First off, thus an eminent case is made out for interference in the matter. Next paragraph. There is force in the submission of Mr. Mohanty that the elaborate order of the coordinate bench in respondents WPC 16921 of 2010 disposed of on 24/1/2019, whereby the tribunal's order dated 8/1/2010 dismissing respondents OA number 593 of 2008 would constitute res judicata. First of all, the doctrine of res judicata, it is said, the standard writers, is as old as mountains. First, the said doctrine has been enacted 1908 CPC during the British regime to a limited extent. And those limits came to be expanded in the 1976 amendment. First one. In other words, in terms of res judicata as has been enacted in section 11 of CPC 1908, the suit can be resisted. First, however, the gamut of this doctrine is much wider than what has been enacted in said provision. And that gamut to take into its class petitions of the kind. First, all these aspects have not been discussed by the learned single judge in the impugned order. First time. Next time. We observe that the learned single judge was swayed away by the principle of parity in view of SP Dash's WPC number 3314 of 2018 that was disposed of on
36/2021.
30 June 2021. First of all, the principle of parity has no place when res judicata operates. First of all, courts have to do justice only in accordance with law. That's how oath is administered to judicial officers. First, doing justice towards law, the horse law is unknown to our system. First, decisions in this regard galore in law reports. First, we do not agree with the well-made submission of learned counsel representing the respondent employee that once a representation is rejected in violation of principle of parity, for similarly circumstanced employee, disengaged employee, Mr. S.P. Dash, there would be a fresh cause of action, in as much as there is infraction of parity principle. Read the sentence. No, full sentence from beginning of the well-made submission, something like that. Yellow, first. Science. Okay.
There will be this possible should be an process. There is infraction of parity.
First. Next part. The last submission of learned counsel representing the respondent that the state being a model employer in the light of apex court decision in Bhupendra Nath Hazarika versus State of Assam 2013, okay, 2013, this is so and so. Once justice is done by the writ court in a given set of circumstances, the intra-court appeal of the kind should not be entertained, is not acceptable to us. First principles having been not noticed, having been not discussed in the impugned order. First, in the above circumstances, this subject succeeds. The impugned order of the learned single judge is set at naught. Respondents WPC number 26558 of 2023 is dismissed. First medicine.
May I pray one thing, Manoj?
Yeah.
Because we will.
It is open to the respondent to seek review of the coordinate bench order dated 24/1/2019, whereby his WP 16921 of 2010 was negatived. First, in that connection, all contentions are kept open. You wanted to say something?
Well, that extremely.
You are a hardcore liar.
Extremely grateful.
Restructure.
Here, my lord, the outside respondent has filed one application for modification of the order.
My lord, I am the opposite party in this side. I am here in BC. I may be hard at the appropriate time.
Yes, sir.
No, this is a order wrongly it has been typed as 2017 in place of 2017. This exactly. The IN number is 4198.
Huh?
1173.
IN number 1173 of 2026 supported by affidavit seeks an arithmetic figurative correction in paragraphs 2 and 5.1 of the judgment whereby appeal was disposed of. A prima facie case is made out for a correction. First off, application granted and correction directed. Registry to correct and issue a fresh copy of costume applied for. Yes. Yes, sir.
Chairman, I have a objection. Recall petition has been filed in a disposed of by the state. Such a recall petition is not reasonable. That is my submission. Only recall petition has been filed. Only on the grounds that that matter on the basis of which you have disposed of, they have gone to Supreme Court. That's all. Not that the Supreme Court has stayed or something, nothing like that. Is the only ground they have taken.
You have approached the apex court against order.
My lord, that has approach and delay was condoned and it is matter is pushed, my lord. So,
how this application is maintained?
No, my lord, that's for my lord. My limited grievances, my lord. That matter was not within the knowledge, my lord, by the time.
So before this application,
exactly. So that I want to.
Why are you insisting for? You cannot challenge these orders are before the Supreme Court now.
My lord, basing upon which this judgment was passed, that is Sabindra Kumar Samal, which was disposed upon 27/2025, my lord.
27/25.
Exactly.
By which bench?
By this bench.
By our bench.
27/25, my lord. 25.
Now, how recall application is maintained?
My lord, on that score, my lord. Because it was not within the knowledge, subsequently it is my duty, being the officers, it is to the knowledge of this.
The very same orders are put in challenge before the apex court.
Exactly. That is the order, my lord, I have given, and the latest one also that I have given kind of a glance, my lord. For that purpose, I filed this application with the innocuous prayer. Page 8, my lord.
How an application to recall the order is maintainable in a disposed of case, that is my point. This is the judgment I have brought.
The very same orders are challenged before the apex court. Then on that ground, we will say that since matter is being challenged, we don't entertain the application. What is this judgment?
So this judgment says that once it is disposed of, that no idea or petition is not maintainable.
Review is maintainable. Recall is maintainable. If case falls into SP Changalawadi,
Yes, sir. Yes, sir.
That is not there.
That is not there.
In all these applications are
yes, sir.
In all these matters, applications, interlocutory applications have been moved, supported by individual affidavits, seeking recall of the orders whereby the writ appeals have been disposed of by this bench. First, learned senior advocate appearing for the employees, respondent employee, submits, and we agree that applications of the kind do not lie except where the principle of except where the grounds of fraud as discussed by the apex court in P. Changalavaraya and Naidu, Jagan, do avail. First up, we notice that such grounds are not taken up in the recall applications, nor these recall applications can be construed as review petitions either. First, in the above circumstances, the applications are rejected in a wholesale way. More particularly, when the very orders which are sought to be recalled are being examined by the apex court in the SLPs filed by the applicant state. Ordered accordingly. Yes, next one.
I have given the details of that, my lord. So far the SLP proceeding is concerned, I have given the details copy. That will be taken on.
How many SLPs you have filed?
Only one SLP they filed.
No, my lord. 4 SLP, I have the order.
So we'll say SLPs filed.
SLP is filed. Because at page 9, I have given the
may not assist.
I have a prayer. I have a prayer. A batch of cases along with these cases which are disposed of by a person order. They are listed on 10 to 2026. Your Lordship same day. Your Lordship directed other matter to be taken up on 23 2026.
Yes.
Somehow it has not been. It has been listed in item number 134.
Today,
can it be taken up sometime?
Post it day after tomorrow in the daily list. Yes. Yes.
Read up the 9 something of 2026.
Yes, Mr. G.
It's a report appeal, my lord, relating to South Florida judgment. South Florida.
Was 197?
197.
2000. How many days delay?
Delay is 415 days delay.
To remit money 20 rupees per day. Same order. And call along with the, if money is order, okay. Posted immediately after 3 weeks. There you have to do 3 weeks. Okay. 3 weeks will be over when? Immediately after 3 weeks. So immediately.
These matters will come on 30th, adjourned to 13th of this month.
But you have to remit that money. Only if you remit money, we will consider your petition.
My lord, should I call this matter? 3 weeks or thereafter.
We can say after 3 weeks. After 3 weeks. Okay. Same order, no? That order. 20 rupees per day. Yesterday also. Yesterday also. Yes.
23 also similar. So the Florida's case.
647 days.
647 days
to 20. Okay.
24, 830 days delay.
Then
same.
Same one.
25.
May please your lordship, my lord. As per the direction of the Hon'Ble Court, my lord, I have the present petition, my lord, deposited 3 lakhs within time, my lord, and the rest of the 3 lakhs deposited, my lord, after the completion of the time, my lord, with permission of the opposite party, my lord. And the present petition deposited 6 lakh rupees as per your direction of this Hon'Ble Court, my lord. My lord, after deposited, my lord, the present opposite party, my lord, taken a physical person in illegal manner, my lord. And thereafter, the present petition also ready to deposit 30% million, rest of the outstanding amount million today million in course of the million.
How much money is paid?
3 lakhs million paid. I have paid 6 lakhs, and now I will deposit 3 lakhs. Total amount is 16 lakhs. 16 lakhs.
Outstanding is 16.
My
lord, may I submit in the above circumstances, application have been favored. No corrective action shall be taken by the opposite parties bank pursuant to the improved notice under section 13(2) of the Securitization Requisition of Finance and Enforcement Security Interest, provided that the petitioner deposit a sum of rupees 6 lakhs in the loan account within a period of 1 year. following which the bank can take all coercive action. As if there is no interim order. What amount the next installment? After he has paid 3 lakhs immediately.
3 lakhs paid on which date?
25 to 26.
25 to 26.
25 to 26.
And the rest of the amount paid 23, 3, 26.
Another 3 lakh is paid on
23, 3, 26.
How many days delay?
1 month.
1 month.
Then after my lord, what happened? We have already gone for the sale. So as per the lord, we have gone for the sale. And I have given a year. Then we have sold the property, issued the sale certificate. When there is a possession question has arisen, we have given a letter, give the physical possession of the earth. I have given the letter to him, which has supplied to him. I can decide. On 9/4/2026, between about 1 month has gone. My lord also directed that put up the matter after 3 weeks. So it could not come due to some other reason.
Now 27 lakh 13,943.
Extra is money. After selling the property, we have got the excess bidding amount. So we have deposited in his loan account. Already property.
You want money or property?
No, my lord, we have sold already.
It's all right. You have sold, it means the auction buyer is having the property. No. Possession is with these people. The sale certificate you have issued.
The sale certificate is issued and
you are
we have already deposited money for this police deposited money for the year. Then my humble prayer is that let the auction purchaser be party to the case. Then whatever my lord.
The auction purchaser. Petitioner.
I am ready to deposit.
First you impede him. He may not agree. In our order dated 17/26, we had granted the reprieve. See, last in the about that only that person. Next paragraph. Counsel for the petitioner submits that his client has remitted a sum of rupees 3 lakhs on 25/2/2026 in terms of the above order, and another like on 23/3/2026, that is beyond the timeline prescribed by the state order. First, he also tells us that he is ready and willing to settle entire outstanding money if a reasonable space is afforded. First off, at this stage, the learned panel counsel appearing for the OP Bank points out that in view of non-compliance of the condition subject to which the above interim order was granted, security property has been auctioned on when? 27 February 2026. Since the order specifically says that non-compliance of the condition would entitle the bank to treat as if there is no such order. First, we are also told by the panel counsel, pursuant to auction, sale certificate has also been issued to the auction buyer. First, in the above circumstances, the petitioner is directed to arrange the auction buyer as a OP number 4, OP number 4, immediately. First off, if arrayed, issue emergent notice to OP number, said OP, returnable within 10 days. 10 days. Okay. You give the particular bank, OP bank to furnish full name and address particulars of the auction purchase buyer of the property to the petitioner instantaneously. Yes.
By tomorrow then.
By tomorrow. Failing which cost may be ordered on the next date of hearing. Yes.
And the list of material after
Just immediately after service of process on the newly added copy. Yes.
Item 26, WPC 3569 of 2023. And for the kids.
Yes, sir.
Today we are filing a counter. In the office of computer because dismissed but referred. So again you are restored. So now we have filed the counter because we have reduced the counter function there. So today we will serve the copy. The proof. Otherwise it can.
Have we taken up on 14th?
No, we have posted many matters. No?
Lord,
We'll have it immediately after.
Small counter, I can Lord file with it.
No, it's all right.
Next week, any time, Lords.
We have difficulty, brother. Otherwise, we would have taken. We'll have it immediately after vacation at the request of. Yes.
Person may fix up date then.
We'll fix some after vacation.
Look with me, Mr. Rakesh. Mr. Rakesh is appearing with me.
Yes.
Rakesh Bear.
Well, counsel for the petitioner and DSG assisted by CGC.
Rakesh Bear, CGC.
Fine. So, for want of time, at the request of DSG, post this matter in the first week of reopening of the court, post summer vacation. Yes. Yes. So, your pleadings are complete in this matter?
Yes.
Pleadings are complete. So we will take up immediately after vacation.
Yes.
Good.
Allotted to Mr. My lord. To Mr. Ponda, my lord, he is suffering IP. Matter we have taken.
Regarding RSC Miller, retired person Miller, already covered matter, Supreme Court already decided.
Lord with judgment.
I did the Lord. Okay.
Have you given the copy to him?
My lord.
Take it up tomorrow.
Advance, they should look into. Then call after, let him read and come. Call next week. You should have given in advance.
But sorry, my lord.
Therefore, call after next week. Yes.
We will pass over.
You read and come back.
Yes.
Yeah.
Item 2.
Kindly taken after vacation.
After vacation.
Then they should serve a copy.
New copy.
Advance time they can serve.
Is there any rule in your state which requires serving of advance copy? Any rule is there, Mr. Party?
I could
New copy. Call after vacation at the request of the council appearing for. Right. In the meanwhile, copy of the petition along with all the documents and applications, if any, supported by affidavits, also should be shared with the learned DSG. Willing which petition or appeal? Petition runs dismissal on that ground. Yes.
Item 27.
2 weeks time may be granted. Mr. Mishra has some difficulties and we also required some discussion with the options.
After vacation, at the request of.
My lords may kindly call us 6th or 7th of July, your lordship.
The second week of June. Second week of.
I was playing for 6th of July, your lordship.
July.
6th of July, your lordship.
Okay.
Item 28, WPC 14250 of 2022.
Yes, sir. Right.
14253 is the one, my lord, before my lords now, my lord.
Number
14253 is it? That's the one, my lord.
Yes, sir.
Yes. Well, impugns the order dated 5/5/2022 of the Central Administrative Tribunal, my lord. Not facts are like this. It's the postal department was the respondent, my lord. There were about 38 people, my lord, in this great petition, not who were in employment on a casual basis. And our claim was they should be made daily wage, what that word, my lord, is, I think daily wage, casual labor or something like that. And my lord, essentially saying that they'll be in the zone of consideration when there's an appointment made, my lord. But they work for, I have given my lord a list of, a list like this, my lord, where the date of appointment, my lord, I have given to my lords, my lord. The date of appointments of these people, my lord. Your lordship has seen it in the last occasion.
Do you have one more copy, two more copies?
Yes, I'll give my lord my copy itself.
Then get the Xerox.
Yes, yes.
Yes.
My lord, the nature of job, my lord, is perennial. No, these are the people, my lord, date of appointment, the following casual labor and so on, so on, so on, who were engaged in several years beginning from so and so, but terminated and disengaged on 7/4/2019 without any show cause, notice or 1 month's wages with the opposite parties. But this is the list is there. The last one, the least amount of time that one was spent is, I think, is 39. 38 and 39, 4 years. 2019 they were disengaged, they have worked for 4 years, my lord.
$38.
38, next page 2, my lord. 38 and 39. 37, 38, 39. They were in employment from 2015. And they were disengaged. They were disengaged in 2019. April.
The years of service you have put in there. That serial number.
Yes, they're different case to case, my lord. Some are appointed, the first one is appointed in 2002, then 2004, 2005, 2010. I took, my lord, just to impress upon my lord that the last one was appointed in 2015. But that's only for the purpose of saying that they worked for 4 years. And they were disengaged. My lord, the tribunal, in the judgment, my lord, finding, my lord, begins at
minimum number of years is how much?
4, my lord.
4 years. 15 and
15, last 3, my lord.
All they are terminated in 2000.
April 2019.
All.
17th April 2019. Well, what happened? They had a change of the place where they were working within Bhubaneswar, my lord. They were working in Bhubaneswar to another place. When they went to there to join, my lord, they were refused employment. My lord, in 2017 onwards, they paid money to them, my lord, through the proper channel, through their bank account. Earlier, they used to pay cash for daily wage. In 2016, they began paying us through our bank account, my lord. I know it's 16 or 17, my lord. I'll just tell that date.
I paid to
No. He paid, I think, 16, my lord. I'm all, just wait. It doesn't really, nothing turns on it, my lord, only to indicate that, my lord, that they were being paid, my lord.
Earlier, when cash was handled.
Yes, my lord. And no,
they were engaged against any sanction post.
My lord, Group B posts, according to the postal service rules, my lord, are sanction posts not necessary, my lord. They are employed. The finding of the tribunal is that they're employed through a system, through the employment exchange, my lord, and they came to work.
All they are employed through implementation.
Yes, my lord.
Ah.
Paragraph 9, page 72, my lord, of the impugned order. It is not in dispute that the engagement of applicants are after following due process rules or after their names have been sponsored by the employment exchange. Rather, they have been admitted by applicants that they were engaged on daily wage labor for 8 hours, for which they should be treated as, that is our claim, full-time casual labor.
Yes.
But this comes to be dismissed on the ground of Uma Devi, my lord, saying that backdoor entry and not 10 years of service, my lord.
Come to para 10.
Paragraph 10. Yes.
Page 77.
Yes, ma'am. Yes, ma'am. That is 10 years.
Kindly read.
Yes. It is not in the case of applicant that they have.
Not the case of
No.
applicant.
Yes. That have been employed for 10 years. No, my lord, it's not the case. That continuously till the cut-off date of so and so. The fixed by the of the DOPT circular number so and so 2020. In the meantime, my lord.
What is that MK Kesari? Is it ML Kesari? Is there any other judgment like MK Kesari? There is ML Kesari, as we know.
That yes.
Wrongly written or any other judgment like MK Kesari?
Wrongly? No, my lord, I think ML Kesari must be wrong, my lord. Because otherwise, after Uma Devi, my lord, there is no other, after the constitution bench, they followed consistently that.
This is a common order or
common order?
Common order. Why at para 11? When we come to para 11?
In view, since 99 in full time, in view of the rules. My lord?
That's not correct.
That's not correct, but 99, not all of them were appointed in 99.
Anybody was appointed in 99?
Yes, where is that?
Nobody.
I think nobody, man. Started in 2002, my lord, September 2002. Yeah, after
only petitioner 22 alone joined in September 2002.
Yes, one.
Rest all afterwards.
Yes, yes. My lord, now, my lord, it seems I'm instructed, my lord, I think I'll give the Legislative Tribunal, my lord, has pretty much following Dharam Singh and Jago, has directed them to be regularized in innumerable cases.
In these matters, in matters like this,
yes,
department.
Yes, yes.
You want
Postal.
Postal department matters?
Yes, yes. Jago is different.
No, it is not postal.
No. Jago is the tribunal judgments. Yes, some tribunal judgments I've seen, madam.
Is there any judgment of the tribunal where
yes,
tribunal has directed regularization of postal device like this?
Yes. Yes, yes. This one, my lord, pertains to, yes, my lord. This is one of the judgments, my lord. This is one of the judgments.
They have given that judgment.
In second copy, is it?
Please do not give anything to us which you do not share with your friends. They will be in a disadvantageous position.
We've given a list of the judgments, my lord, including these.
The difference here is 2001.
Yes.
Since 2001.
Yes, yes. My lord, I bow down to that, my lord. My lord, but
any case where the employees of the kind have been regularized.
Of our kind, my lord.
Yes.
Specifically doing this very job. Similar to drivers have been, my lord, and drivers have been, and two drivers have been.
How many years of service they have to give?
Yes.
Where there is sanction post, we have regular. So these are the post, you may see the page 46 annexure 7. The order will specify what sort of job it is, how many times they are given. I'm specifying, I'm just saying, my lord, just,
even today, my lord, they are employing 45 people. Today, for the same job. It's perennial, my lord.
The Business Processing Center National Sorting Hub book now and pay letter are new concept of the department for the post of deal with the business articles and speed post articles. Since these are not in the permanent establishment and the volume of work is fluctuating, these offices are manned by the engaging outsiders on daily wage basis. The applicants were those engaged to carry out such type of intermittent nature of work, which are outsourced pending on the volume of works. And the applicants by representation have requested for their engagement as a casual labor and denied for pay and allowances, demanded for pay and allowance at the casual level. So if they are coming under that category, the CORAM is CGIT and they should act on that way. Number two, these persons those who have engaged is a latest category GDUPM. That is the Gramin Dak Sabak. There is GDS. They specifically they are not postal employed, they are not civil servants, but postal department is giving and they are coming on that category. Otherwise, those persons are engaged by the postal department, sometimes for 1 hour, sometimes for 4 hours, sometimes for 8 hours, sometimes for 5 hours.
Where is in your reply all this?
All this, that is, Lordship, see the page, annexure 7, page 46. That is the order passed by the...
No, where is your reply to this in the tribunal? What is that you have taken?
That argument I very advanced about the labor code, that is not there anything, but other argument is page 66.
What are the grounds you had taken up before the tribunal to rest their OAS?
We have filed the counter that was page 66 of the tribunal's order itself. The paragraph, internal page 18, running page 66. The counter has been filed by the respondent stating that no casual worker has been engaged since 29/11/1989.
What is this order of report? Where is your counter?
Yes.
Show from the counter what is the stand you have taken. Because we can't go by the version of the CIT because it is saying they were appointed in 1999. It has not seen
the order from
so let us
copy of the counter, copy of the judgment.
So if you are using this one, I pass the order.
Again,
page 82.
We need counter now.
Yes.
Do you have sir counter? Do you have?
Yes, yes. Page 82, my lord. 79 onwards, my lord.
Go to 79. Where is what the stand they have taken?
Stand, yes.
79. 7 line.
We didn't have the copy of the counter filed before the tribunal, but we have the copy counter filed in this case.
Yes, yes.
This is yes. That counter is in 7. Yes.
Yes, it started 7.
Then we file there, file rejoinder, we file the additional affidavit. In that additional
No, what was the counter? How you will find counter here? Whatever you have filed there. See, the whole procedure in your court is some, with due respect to the registry, I am telling this. How petition is, formats are made in other high courts. Writ petition. Annexure A or Annexure 1 will be the impugned order of the tribunal. Annexure B or Annexure 2 will be the entire case papers of the tribunal. This is only 227.
This was also adopted by the coordinate bench prior to that Justice Sawad, but thereafter again it was adopted. Immediately everybody is filing this end. But ultimately again it is done.
No, why counter here? Counter you should be you should have filed counter
Yes, we
there.
have filed, but then-
That counter, unless
I'll
facts have come.
let's keep it to next week.
This is counter filed here in this court.
Yes, yes.
Where is the counter filed before the tribunal?
Unfortunately, my lord, we have not annexed it.
That is,
There's a shortcoming of ours also, my lord.
Whatever stand.
I have to, my lord. I should have.
Battle lines
I bow
are
down.
drawn.
That should have.
The tribunal. Based upon that, we should decide here. It is 227.
Yes.
This is not appeal.
Yes, yes. The counter in the trial. But I've got the tribunal counter, my lord, copy with me. My lord, may kindly. ये जो जजमेंट था सेकंड जजमेंट था तो लेकर अब वो तो applicant to call them.
See, how long you have taken services of these people?
It is a completely temporary nature of work. That's why I'm referring to this order of the officials in the Annexure 7. It is a particular job. It is a particular job pertaining to the
Whether that stand was
business
taken.
processing center.
Was it taken before the tribunal? Such a stand was taken before the tribunal.
Yes, because tribunal has narrated the order. We don't have a copy. That's why I will not put it. Let's keep it next week. I'll come with the all documents and apprise the court.
You serve a copy of the reply which they had filed there.
Yes.
So that the pleadings will be complete.
If I can get that back, I can make a copy. And
we'll give them. We'll give that.
And this prayer of this before tribunal of the applicant is regulation of the temporary
temporary
status. Not about the appointment or regulation.
No, they say about the full-time casual work.
Yes.
Whatever they have claimed
As if my lord
is less than regularization, according to you.
Yes.
Give that. You take this
thereafter this casual labor and demanded for pay and allowances as that the casual labor.
They have taken a stand there that since 1989 there is a circular not to. But how you have taken it to 31?
93 till 93 they make a clarification. And they also say, my lord, for D category, my lord, it's not necessary a sanctioned post to be there. Because these are work charge, and because of the fact that they have perennial work, 8 years.
Outsourcing, that's not ended.
No, you have asked for the requisition, then sponsored through the
employment exchange.
Unless there is a requisition also, sir. They cannot
do employment exchange.
So without a requisition, how why employment exchange sponsored? You must have given the age of that particular the qualification. That must be there. Without that,
you give whatever document you have given to the employment exchange that we need. How employment exchange operates? It's a the potential employer sends the requisition to the employment exchange. We need so many people. Then they will make the panel. That panel is sent to you. Therefore, your contention that we have outsourced them through an agency is not correct. Otherwise, because you have admitted, somewhere it is, I saw that sentence, that they have been drawn from employment exchange. How is there an Employment Exchange Act is there?
Yes, my lord.
How that operates?
That
you give
exactly as my
description of the act.
Exactly, my lord, was what fell from my lord. My lord, there has a panel made, and they go there and ask, make an indent, and it comes from them, and they select from them, and it goes by a circumstance which is clearly followed, my lord.
All were engaged through employment exchange.
Yes, my lord.
Registered. These people must have registered.
That's why they say, may they clarify on the letter itself, page 47, first paragraph.
Saying?
As regard to that, may I read my? In the instant case, the applicants are being engaged by different authorities and the offices to work on daily basis on the different days, depending upon the volume of works at the above offices. All outsiders are engaged purely against the internet variations.
No, that is your letter.
Variation.
That is your letter.
Impression of the work load, which is a temporary in nature. They are not.
No, there is not even one single sentence as to you having drawn them from employment exchange.
Then there must be in our counter. Yes. We put the cat.
Otherwise, how that will
land cat? Yes, I will like it.
Just look into Employment Exchange Act also. Any standard judgment which has interpreted the provisions of the Employment Exchange Act.
I will definitely, my lord.
Assist my lord. Yes. Reading.
Yes,
you will be spending time like.
Yes, no, my lord. I will give you. But sad thing is, my lord, today, what they do, these people have utilized, they are all overage. Now they take up another 50 people for the same job.
Through agency or?
No, direct, my lord.
Directly.
Yes.
Directly we do that. Now whatever we are doing.
No, because of the necessity of the work. But as far as D categories.
But how did they choose these people?
They just pick and choose.
Oh, that means they called a group.
Yes.
And they start working.
My lord, one of
Sardar might be.
Yes, interestingly, my lord, 5 of us here are also working there. 5 of us. Yes.
Is it through agency?
No, my lord. Which agency? I don't know, my lord.
Through agency.
I'll get it.
No, let them say something.
Outsourcing basis. There is a confirm.
In fact, they gave us money increase. They have given us money through our bank accounts directly from the postal department.
That was not from the beginning.
No, because I wrote. I wrote that why are you not giving us? And we wrote, and then they themselves regularized it, and then they were giving us, my lord, lower than the minimum wages. Minimum wages. They made it at par with the regular employee later.
Is it?
My lord has decided a similar matter, but there, my lord, there was sanctioned post of 170.
That's what.
That's the distinguishing feature.
But they all have
Working.
more than 10.
Yes. No, my lord, here, my lord, the tribunal is even at times, my lord, 2 years, 3 years, if they have regularly and
What we want. If you can show that.
we'll give all those judgments, my lord. I'll give my learned friend also.
Take the tender and taking the outsources. It was to start has been taken before the Lord Central Tribunal. It was also reflected in the
Order.
Yes, page 18. The next case, page 18. Lakshmi.
No, the tribunal has.
Yes, I'll prove the case. Whatever counterpart will produce.
That-
Along with the application, the
Because apparently there are mistakes. The tribunal case, they have been working since 1999. The last paragraph, which is not true. Apparently, even that is there. That is not there.
That's not our case.
The tribunal has gone in a tangent.
by the way, we missed you. The next case, there is 19 issues.
Oh, okay. Soon after vacation.
Whichever date, my lord, may fix, my lord.
Immediately after vacation. Yes.
Item proceeding.
This one.
Item proceeding.
Another 50 people you have taken.
Yes. 45. 45. 45.
40,
I also take instruction over
You
them.
take the instruction. If they have been working, not regularly, after you want to take other people to continue.
Yes,
That means at
whatever
least
cases I have discussed with them, in each case they are doing the outsources. Now there is no system for getting directly for anything. We are putting in tender.
Next date you have to say whether they were drawn from employment exchange.
Yes, ma'am.
If you have drawn them from employment exchange, your requisition which you had given to the employment exchange, that copy you have to give us. Learned DSG to produce the files relating to drawing off the petitioners from employment exchange and the interaction between the jurisdictional employment exchange and the postal department that eventually resulted into engaging the services of the petitioners. First off, an adverse inference may be drawn if such information or documents are withheld from the court. Okay. Let us see.
Regarding, my lord, that they're letting find out, my lord, whether they're employing today 45 people for the same job.
He should also state as to whether post disengagement of the petitioners, any other persons have been engaged to do the work which petitioners had been doing till their disengagement.
Item 29, 31 have been adjourned. Item 32, wait appeal 3354 of 2024.
Yes, sir.
The matter related to compulsory retirement, my lord.
Compulsory retirement. What was the designation of the petitioner?
The Assistant Conservator of Forest.
ACF.
ACF.
How many years of service he has put in?
I had put in 34 years.
34 years.
34 years of service. Initially joined.
He initially joined as
Forester.
When?
On 8/12/1986.
Then promoted
to the post of range officer on 5
range forest officer.
Range officer.
Range officer.
Yes, range officer forests. On 5/8/1996.
Then I was promoted to the post of ACF on 26/9/2018. Then the order of compulsory retirement order of my lord on page 48, my lord. Page 48.
Dated 22/7/21.
Sorry, my lord. 46 page. 46, my lord. 20th January 2021. As on the date of review, my lord, I had already completed 56 years. That is mentioned in the input order, my lord.
Review was done when?
Review was done, my lord.
On which date?
Yes, my lord. On 18/1/2021. 18/1/2021.
Where is our judgment, Sahu's judgment?
Yes.
That is affirmed by the Supreme Court.
Yes, ma'am.
Supreme
Yes.
Court
Yes.
directed reinstatement.
Yes. Direct reinstatement.
But other day, Mr. Mohan said it is reversed by the Supreme Court.
Yes,
it is
yes.
affirmed by the Supreme Court.
Yes, yes. This is the judgment of this on Court of Lordship judgment, and this is the Supreme Court judgment, ma'am. I'm giving to the Supreme Court judgment. Here two this Supreme Court.
Which paragraph in Sahu's judgment will come to your aid?
Yes, madam. Here is judicial officer, my lord.
You are citing that Sahu's judgment. Other day you said.
I am citing another judgment. One judgment of this Hon'Ble Court, single bench judgment, my lord. We directly covered. The review would not have been, they had no jurisdiction to conduct the review after completion of 56 years, my lord, 55 years. That is, my lord, I have given my judgment to my friend, my lord.
That review is done under particular rules.
Yes.
Any rules are there in your state?
Yes, my lord. 71. This is the judgment, my lord.
Secretary special
I have annexed guideline. That is page annex 9, page 49 of the writ appeal.
Guidelines. But we discuss something about rules also, na?
Yes, ma'am. Rules, that guideline, ma'am. Rule 71 empowers the Rule 7. Under Rule 71, this guideline is issued by the government of how to proceed with the compulsory retirement board.
Can we face 71?
Yes, ma'am.
This one. Yes.
Small a.
71 small a.
71A.
Here, your client had crossed 55 years.
55 years. 50. The order says itself, my lord, had completed 56 years.
When he was born? Give his date of birth. Because we very casually say our age.
On 11/9/1964.
11/9/64. So he will complete 60 years. This is 58 years retirement.
60 years.
60 years.
Yes.
He will complete 60 years on 10/9.
24. I have already attended that day.
But the review was undertaken when?
Review was on 18/1/2021.
21. What was his age?
Age was 56 years, my lord.
How? There is the Indian Majority Act 1875, which gives the idea as to how the age should be counted.
Yes, 56.
So it will be less than 56.
56, but
it says 55 years. Kindly read. Government said in the 55 years of the age.
Yes, 55 years. 55 years of age.
Up to one day prior to he becoming 56, he is 55 only.
Yes.
Under the Indian Majority Act, he continues to be 55.
Completed 55 years. Completed 55 years.
That's all.
But in the order, my lord,
They may say it wrongly. Now you have given the date of
completed 55 years.
He completed. Yeah,
as on the date of review, my lord.
55.
Yes.
Rule reads in the band of 55 years.
Yes, in the band of it.
So that guarantee is not available to you.
And that is available, my lord. Because of the LRCC, the guideline, my lord. And the judgment I have given, my lord, as for the guideline LRCC.
So your first ground is no review could have been undertaken.
Yes, my lord.
Because he had crossed 55 years.
Yes, madam.
That makes no sense.
Yes, madam.
The word, kindly read the text of the rule.
Then crossed 55 years also, madam. 55 years. Until 55 years. He had crossed.
If he is in the 55 years of the age.
Completing last, madam. 55 years. In order to determine whether he or she should be allowed to remain in service up to the...
Before that other point is not much relevant. Yes. How the age you are determining.
Yes.
Read that provision. It must be the government service it is, not servant.
Government service.
Service. There is some mistake in the print.
Printing mistake. Except, I am reading 71A.
Subject to the condition that a review shall be conducted in respect of the government servant in the 55 years of the age. In the 55 years of the age, that is
55 years of the age. In order to determine
whether he should be retained or not, continue to be or not. That is the object of the rule.
How to attend that, my lord? That is the guideline, my lord. Guideline issued by the government, my lord. That guideline, I have given that guideline, my lord. Page 49, Annex 9 of the writ appeal. Clause 7.
No, you say review was undertaken on 18/1/2021.
Yes, ma'am.
What was his
on 18/1/21? 18/10. Yes, 18/1. Sorry, 18/1/21.
Then it is in the range of 55 years.
55 years, my lord. What guideline says, my lord, before putting to review, my lord, before 6 months, that is also, I am taking a lordship to the guideline, my lord, paragraph 7.
These guidelines have been issued By whom, under which provision of the rule?
On the Government of India, under Rule 71A.
Government of India?
The Government of Orissa, sorry.
Orissa.
Government of Orissa, under 71A.
71A?
Yes, ma'am.
Where it gives empowers?
That is page 49, paragraph 3. Page 49, my lord.
49 of your...
Writ appeal.
No, that is the guideline you are saying, na?
Yes, my lord.
Where is the power to issue guidelines?
Because that guideline itself is a resolution. LOC is paragraph 3 of that guideline, ma'am.
The periodical review.
Yes, ma'am.
Please read.
Paragraph 3, my lord.
Yes.
With a view to ascertain whether government servant would be retained in service or retired from service in public interest, there is absolute need for periodical review of performance of government servants. Provisions in this regard are contained under proviso to clause A of Rule 71 of the Service Code. Government have accordingly decided that the following instructions procedures shall henceforth be followed by the authorities empowered to conduct review or issue orders retiring an employee permanently, prematurely, as provided in the proviso to clause A of Rule 71 of the Orissa Service Code on his completing 30 years of qualifying service or attaining 50 years of age and on his attaining 55 years of age. There are lots of clause. Turn to next page, page 50, my lord.
No, what is meant by this? Now you have read, na?
Yes,
so
ma'am.
draw meat from that. What
that is clarified in paragraph 7, my lord.
No, what does it say first? Then we will go to clarification.
Yes. There are two stages of review. Review must be on completion of 30 years of service or attaining 50 years. 50 years.
Of age.
50 years of age. And there are second review, two stages of review. On his attaining 55 years of age.
There are 3 stages, even in 50.
Yes.
Even in 50.
30 years.
No, 30 years
age.
or 50. 30 years or 50 years.
50 years of qualifying service.
Completion of 30 years.
Provided anything after the wedding. So before the wedding, that is. So see if the group is additional database, small danger. Taken out of so by like balance compared to this whole life. They provided that the government servant may be retired from service anytime after completing 30 years of qualifying service or on attaining the age of 50 years, by giving a notice in writing to the appropriate authority at least 3 months before the date of which he wishes to retire. If you no, this is by him. Yes. I want to take PRS. Only to them. The 30 years of service.
30 years or attaining 50 years.
Or on attaining the age of 50 years.
Which is later.
That is not there. So they're independent.
Yes.
Independent. Even if 30 years is
yes.
So to complete 30 years of service,
one may not be 50 years.
One may not be 50 years. how courts have interpreted your various judges have interpreted this provision?
First, Lordship, for my I will take Lordship to this guideline, paragraph 7. Paragraph 7, madam. It will convenient for Lordship, got it, madam?
Yeah.
The cases of government servants covered under clause 4.
Covered under paragraph 4.
Paragraph 4.
Reading, don't change the words. Every word will have some meaning. That's the reason.
Covered under paragraph 4 above should be reviewed 6 months before. That is important, madam. 6 months before they are completing 30 years of qualifying service or attaining 50 years of age, and on their attaining 55 years of age, as the case may be, as for the following time schedule. Then time schedule is given at this.
Now, why 55 years is rule proviso 2? We are saying something in your favor. Kindly lend your ears to us. We are saying something in your favor. Kindly come to Mr. Behura. Come to proviso 2, 71 small a.
Provided that a government servant may be retired from service at any time after completing 50 years
of qualifying service, one circumstance,
or attaining the age of 50 years.
Other things may not be necessary because it relates to he is applying for VRS. You have put another extension of 55 years. Where from you bring it?
My lords, that is
$71 small a.
My lords, small a. Shall be conducted in the 55 years of the age in order to determine the whether he should. Clause A says 55 years, my lord.
Any judgment which has interpreted this provision?
Yes, madam. That I have given back, sir.
You accept.
A single bench, a single bench judgment, my lord.
All right. Which paragraph?
My lord,
71?
Page. I will take a look at page 1016, paragraph 3.12. As a Lordship, Rule 71, they have dealt in paragraph 3.3. Since guideline issued under
No, unless guidelines have got statutory force.
Yes.
Their violation will not give a cause of action to you.
Yes, madam.
That will not be a ground to you.
It has a statutory force, madam. It is
how to know it has statutory force? Which rule says the government can issue guidelines for implementing these rules? Where is such a provision in your service rules? Because several high courts, including the high court from which I hail,
yes,
they have taken the view. The violation of executive instructions will not give rise to a coherent cause of action. Any executive instruction, like for example, which is that famous judgment, take out that judgment of the apex court. Fernandez versus State of Mysore, or State of Mysore versus F. Fernandez, or E. Fernandez, something like that. Constitution bench judgment.
Judgment.
But my lords, provide you for the employment.
Therefore, let's employ you.
One judgment have already given. That is in record also, my lord. 1977 Supreme Court.
No, what Mehra says is correct. 71 Supreme.
The guideline on the since when rule does not
Where rule is not coherent,
yes,
or not implementable in the absence of some guideline, then Supreme Court said guidelines will partake the character of rules only.
Yes, that is 1977.
But that is not the case here. Well, rightly now, Behura has answered the point. See, the first proviso is employee-centric in the sense it gives right of VRS to you. Is right. Otherwise, there would have been discordance between 1 and 2. You can apply for VRS in two circumstances, where you have already put in 30 years of service, qualifying service, or you have crossed 50 years.
Then
in these two conditions, you can apply for VRS.
Yes,
not a case of VRS.
No.
Therefore, we are miles, your case is miles away from the first proviso.
Second proviso.
Let us travel to the second proviso. Did you get that judgment? Yes. G.J. Fernandez versus State of Mysore. 67 Supreme Court. There the Supreme Court said the executive instructions are not of binding nature and nobody can come to court alleging the executive instructions have been violated. I think that related to for Karnataka Public Works Department Code, PWD Code. PWD Code.
1967.
Supreme Court.
Yeah, thank you.
How many? No, okay. Not waiting for this one. How many judges? 3 judges. 3 judge bench decision. Yes. It's reiterated also 2011 or 12, reiterated. Therefore, unless you show a provision in the rule which authorizes the government to issue the guidelines, that may not be of much help to you. Anyway, that being said, now let us travel to the second proviso.
Provided that implicitment.
Where?
71A, second proviso.
Second proviso.
First proviso. First, 7. Provided that the government may.
No, you can apply for VRS.
No, second part, my lord. Provided that the government may be retired.
That is the first proviso.
Yes, my lord. Only that
first proviso.
It is a complete part.
Compulsory 71A, my lord, not provided. 71A. Except as authorized provided.
That is what? First paragraph.
First paragraph, my lord. First paragraph, my lord. Except as authorized provided in the
other clause of
another clauses of this rule, the date of compulsory retirement of government servant, except a ministerial servant who was in government service
on
31st March 1939 and class 4 government servant is the date on which he or she attains the age of 58 years, subject to the condition that a review shall be conducted in the respect of government servant in the 55 years of age in order to determine whether he or she should be allowed to remain in service up to the age of completion of age of 58 years. Now it is 60, my lord.
Or
or
completing the age of 55 years.
completing the age of 55 years in public interest.
What does it say? Explain to us.
Government has to make a review, my lord, before getting in compulsory retirement, my lord. Before effecting compulsory retirement, government has to condition a review shall be conducted in respect of one sir. In the age of 55 years.
Yes, they have done that.
In the age of 55 years of age, in order to determine
whether he should be retained or not.
Yeah,
till he attains the age of 58, then now 60.
Yes. 55. Now, how the review will conducted, that is guideline says, I will take, if you will accept the guideline, if it is not authorized, my lord, this compulsory retirement is a punitive one, my lord, in my case, my lord.
How?
There are two departmental proceedings, my lord. Those two departments, I gave the reply, my lord. They did not conduct the inquiry. I submitted the so-called reply, my lord. Those allegations are not attributable to me at all. They did not conduct an inquiry. Those two department proceedings took in the review for my compulsory retirement.
They were made part of the decision.
Yes, that is the decision.
Where is that? Where you will? How you will demonstrate that? How you will work out the nexus between the intended departmental proceeding? It was not a case of departmental proceeding because notice was issued to you.
Yes, madam.
And you replied to that.
Yes,
at that stage, it does not take the character of departmental proceeding. Under your rule, the departmental proceedings are deemed to have been instituted as on the date the memo of charges.
Yes, memo of charges, my lord.
So no memo of charges was given to you.
Yes, madam.
Was it given to you?
Yes, madam. Memo of charges, my lord. Let's say page 19. There's two proceedings, my lord. Page 19. Yeah. Let's got it, man. Enclosed please find here with Government of Orissa PA Department Memorandum Society initiating department proceeding against you. Then let's it on to the next phase, memorandum. Communicated.
So statement of imputations was given to you.
Yes, ma'am. And I have given the reply also, ma'am. But no inquiry was conducted.
What was the allegation?
Article page 22 is the articles of judgment.
Many elephants were dead. How many elephants were dead?
Two.
Only two.
Allegation is two.
But you did not hold the inquiry.
And I've given him a reply of ending the charges, my lord. That's not attributable to me, my lord.
It's not
attributable to me at all, my lord.
How?
I've given the reply, my lord, because I protected the my lord. It is the I have given the reply in 3+26 is my reply, my lord. Page 20 was
Mr. Behula, please come to page 26, excerpt 3. Paragraph 1. Come to the middle part. He was attacked by the poachers twice, and he was admitted to the hospital. He suffered brain hemorrhage. What else he can do? And he was hospitalized.
After that, here allegation is that even for 20 days he had no knowledge of
carcass. How big the forest is? What is the aerial extent of the forest and density of the greenery? And how many people were posted there?
I don't have an idea what is connected to Jharkhand also, my lord.
If you say like that, you should say the how many people will be there? How many? Because sometimes it is very difficult to go to the nook and corner of the forest for several reasons. If the forest is very, very huge, death of the elephant will not be known, because every corner they cannot go, and the death of an elephant may happen in a remote corner. Not
No, it's a Puldia is a very big area.
Very big area.
Vast area.
Attached to Jharkhand, West Bengal, Jharkhand.
My lords, the other.
The point is, what we have to see in compulsory retirement is he productive to the government, public service?
My lord,
is he honest?
My lords,
2 questions.
My lords, kindly see the next charges.
No, but you have not held the inquiry only.
My lords, the review board committee, whether he has applied its mind and there are materials before them.
What is that material?
My lords.
On what basis you have taken a decision to compulsory retire? Just show it. He is a person who has put in 30 years of long service. He has secured 2 promotions.
Well,
2 promotions he has secured.
My lords, the second charges that he has not furnished the property statement, and there is a vigilance case for disproportionate assets.
What happened to that case?
That is under investigation.
Still not investigated.
It is being investigated for another century.
It takes, my lords, then a year, usually it takes time. My lords, my humble submission is that
whether a charge sheet is filed in that case, charges are framed. Vigilance is whether at least charge sheet is filed by the police.
That is instruction, I do not know.
Then,
my lords, kindly see the minutes of meeting of the review.
Page?
Yes.
Read count, government count of
government counter BY1, page 12.
74 of the read petition.
74.
Read continuous page 74.
Let's
give that sound judgment for a moment, just for a moment. We have considered one aspect of the matter. One paragraph I remember, where they did not hold the inquiry.
Yeah, Supreme Court judgment.
No, so affirms this judgment.
Yeah.
Just go to my judgment. Our judgment. Come to page 11.
Well,
Clause B, 3B.
my lords, the vehement summation of circumstances that the decision to prematurely retire what service records is very difficult. This is for some.
No, sorry. Come to page 14. 14B, E. 14E.
Well,
read.
there is one striking aspect in the matter. The allegations were received regarding the manipulation of depositions of asking the advocates to practice for women and money. Despite such wild allegations, no disciplinary proceedings were done. Apex Court in May has observed that an order to compulsory retirement cannot be passed as
a shortcut to avoid departmental.
Yes, my lord. That is also in our guidelines to avoid departmental aid. When such course is eminently desired, it is also said that if the officer was given a promotion despite adverse entries, that is a fact wherein in favor of the...
See, now you propose to hold the disciplinary inquiry.
Yes.
And you asked him to show cause. He has shown the cause. You were happy with that. You did not hold the inquiry.
My lords, in the meantime, this review.
No, therefore, review cannot be founded on a dropped inquiry.
Well, no, it is not a dropped inquiry.
No,
tendency of he submitted his reply. Before proceeding with the matter, the review committee decided.
No, what points it took into consideration? Where is the objectivity?
My lords, can you see the
order
minutes? The case of 5 persons were referred. Only 2 were.
Now, who were the members of the committee?
My lords, kindly see
PCCF,
my lords,
representative of GA and PG department, joint secretary to government, under secretary of forest department.
My lords.
What is that they have looked into? What happened to your criminal case? Whether charge sheet has been filed?
It is still pending.
No, case is pending is true. Any charge sheet has been filed?
I have taken some the charge sheet filed.
Mr. Mayor, what are the points considered? Just show us.
My lords, phase 13, next phase. A lookout case number this was registered against Lakshman based on a complaint alleging serious corruption in pursuant to the order the Honorable Lockout Orissa Vigilance case number 47 dated 4/10/2019 was initiated against him. He was placed under suspension.
By order no session, sir. Letter 20th.
On the report of SP Valeshwar, on the recommendation of GA Vigilance Disciplinary for acquisition of costly immovable assets without obtaining prior permission from the competent authority, wherein the following charges were carried.
No, what was the charge? Is it a DA case?
Well,
disproportionate of assets or without permission buying the property? Which is the case?
That your lordship kindly see the
Acquiring property without permission of the employer is one misconduct. We agree. But acquiring property disproportionate to known sources of income is another. Which is the higher?
Both are. In vigilance, disproportionate assets case is there, and purchasing assets without permission, there was charges. Kindly see case 34. The writ petition. Annex 2.
Writ petition.
Look at the minutes, that is 40. 40 page 40 minutes. Form A. Form A. Page 40 in my brief. Property list of Lakshman Kumar Pradhan, Forester.
What is that? Ghara Badi?
Homestead. Homestead.
The two properties. The third property is a paternal property.
Minutes in 2001. 2,15,000 rupees. Now it will be 2 crores.
No, we do not know. In 2001 it was bought. What was your salary in 2001? And what is the percentage of excess money? In DA case, what is the percentage?
My lord, that instruction.
How many?
That instruction must be there.
No, see.
That documents are not with me.
No,
vigilance case.
Either you are conducting that, you means whoever is conducted earlier. You can't improve that is another thing. But what is the correct approach to the case?
My lord, here, these are the properties he has bought without permission of the authorities, which is required under the service.
Take action for that, but why compulsory retirement?
Well, these are the conditions to be looked into, my lords, and the vigilance case, disproportionate asset case.
All right. He bought the property on 3/9/2001. Correct? You gave the promotion.
It was not brought to the notice.
That's not your case.
Well,
that's not your case. Because in Sahu case we held, once a promotion is given, whatever arguable misconducts, they stand abated. See, in 2001, he bought the property. His wife bought the property. We'll assume that he bought it in the name of wife Penami. Okay. After that, you have given him the promotion on 5/8/1990. Sorry, that is 26/9/2018. Is it your case that he did not inform acquiring of this property to you?
No.
Because in South's case, kindly read it. South judgment.
No.
In South judgment, we have held. Kindly come to page 14, class E.
Yes, ma'am.
If the officer was given a promotion despite adverse entries in the SCRs, that is a fact weighing in favor of the employee in the matter of compulsory retirement. And we did not hold any inquiry with regard to that one. You have not served any charge sheet against him. You have not made any adverse entry on that basis in his service register. Have you made any?
My lords, charges were given, my lords. 17/11/2020.
2011-2020 for acquisition of property in 2001 after 19 years. No, brother. If you are going to see person who has suffered, who has fought with the poachers and got his skull broken, who was hospitalized, who suffered hemorrhage, brain hemorrhage. If for such person also, if you are treating this way, what about the morale of others?
That is only his statement.
Now, where have you denied?
I was awarded.
You should have held the inquiry saying that you have given cock and bull story. We don't agree with this. Enter the witness box.
No, he was awarded PG Patnaik Award for the best.
Award is also given.
Getting award is different thing.
How? How it is different? It comes to his aid. And you did not hold the inquiry at all.
What I only submit, my lords. The committee review committee, they have applied their mind.
No, always will say like that.
And there is no malafide there.
Malafide cannot be.
So, they seeing the conditions to disciplinary proceedings. Prima facie,
no.
My lords, vigilance case is pending.
Therefore, we ask you, what is the status of the criminal?
If your lordship, Monday I can.
Oh, no. We have heard enough now. We cannot go on adjourning the matter. That many people will be looking at us.
Only that purpose, your lordship.
You just telephone and ask your PP, public prosecutor, whether in that charge sheet has been filed, charges have been framed. And what is the percentage of excess of income?
Yes, that should be.
What the vigilance people are government, my doctor and
you ask your client over phone.
My son and daughter.
Charge sheet has been filed.
Yes, I have.
You ask him.
My son and daughter both are doctors, my lord. And they took all their properties included in my property, my income. My wife also doing this in business.
When children became doctors, which year?
That I will.
Wife conducting business, being a government officer, have you informed the authority that she is in business? That is equally important under the code of conduct for government office.
You can't prevent the wife from doing the business, but you should tell the government, my wife is doing business. Even when I say no, she wants to do her business. That you should have informed.
The total punitive action they have taken under compulsory.
In English law, till 1891, wife was considered to be part of husband. And if the husband were to beat the wife to death, it was considered to be half suicide, which was not an offense. Therefore, all husbands were let free. Then in 1891, Parliament amended the law, saying that wife has got her independent status. Here it is not like that.
He was placed under suspension and reinstated.
Reinstated also.
Yes.
No, my lord.
Huh?
Reinstated. He has not reinstated.
Then, while under suspension, this review was taken.
Yes.
Is it? I read somewhere that.
But the superintendent of police has recommended for reinstated.
Police recommended.
That I read. Correct.
The SP Vigilance recommended for reinstated, and on his recommended there was no criminal case made out.
On that. On the vigilance count.
Order appears to be punitive. Order appears to be punitive. So that all that has not been reflected in the puned order, that can be made out by lifting the veil.
The purpose is to see whether is continue in public purpose or not. Conduct raises doubts, my lords. They review.
No, we can doubt everybody. There is a sloka in Bhagavad Gita. Samshayatma pranashyati. In Bible also, doubting Thomas will wither away. So you can't go on doubting everybody, everything.
No, but it should be backed by some documents and facts.
Just tell us whether sir, you inquire with your client whether charge sheet has been filed.
Yes, please. Within 5 minutes, sir.
Yes.
I will come back.
You can speak from here also, no issue. We are not offended when the phones ring here. We treat them as the church bells. Mr. Behura, it appears there is a case for him.
Well, but by now he has attended the age of.
Correct. Yes, but this order should go. At least he can, wherever to the functions, wherever he goes, he can have a copy of that and show to all people. See, High Court has granted us relief, though government did not treat me well. The stigma in the evening of life will be a bit difficult. People will be pointing out it. And whatever he would have earned had he not been compulsorily retired, that has to reach his hands. With some concession, whatever amount you say.
Right, otherwise,
public money. Public money, but you kept him away. He did not.
It is not one-sided. He is a contributory. He has also. Now, what is the extent of this proportionate?
That extent you are.
That you
have to disclose. That sheet has been filed. That sheet has been filed.
Right, and
cognizance is taken.
23% excess taken.
23%.
23%. And I include adding the income of my son and daughter for that. 23%.
After
giving the 10% excess
10%
discount.
at the end, it is given. In trial, conclusion of trial.
So it will be 13%, even going by that. Because Apex Court said, which is that famous judgment, where it said if it is up to 110% is permissible. There is one such judgment. Whether charges have been framed now, whether charge sheet is filed, charges are framed
also.
But as on the date the compulsory retirement order was made, charge
No,
was not.
there was no charge was filed by the court.
Which is that, what you call it, criminal case? Vigilance case. VGR. What is the case number? Vigilance case number?
My lords,
It's called VGR. What is the case particular?
vigilance case number 56. No. Vigilance file number 47 dated 4/10/2019. Baleshwar.
Now, in the article of charge, it is not there.
Whether that was considered by the committee?
Yes, well.
Vigilance case is committee considered. Then what is that award you secured?
I have awarded four times for protecting properly and the forest area, and also catching some forest
Poachers?
Yes.
4 times 7 it was.
No, you got only twice in 2015 and 16. Vijay Patnaik Award as Best Forest Ranger. In 2015 and 16.
Best forest ranger. Chief Minister's Award or only in the name of?
Vijay Patnaik Award is in state award. It's a state award. Government sponsored.
Kindly be seated. What should be the amount? See, sir, your client has not worked. He was, because he was compulsory required.
No.
But full amount you cannot expect.
That was just
He must be getting pension.
No, till today they have not got pension.
So that is because of other reasons.
But provisional pension must have given.
No, they have not provisional pension, also not sanction mine. Till today they have not got given.
We will then we will crash this. We're just proposing. We do not know. When we start dictating, we may go again to the other point. No? Just in the event we have the petition. The monetary benefits you will not get. You will get the monetary benefit only in the event you secure honorable acquittal in the criminal case. In the light of that, which is that? Ram 2021.
2024. Yeah. In the vigilance case.
That's the reason why you are not being paid pension.
But pending vigilance case, pension cannot be said. I am entitled for pension also.
We have made similar orders where it will be subject to succeeding in the criminal case.
In Sanjay Sahu Supreme Court case, they have said to pay the entire amount, my lord. In Sanjay Sahu's case, Supreme Court said.
But that was not a case of vigilance. It was not a case of vigilance.
No, that has been given. But at the same time, the order passed by the division bench has been kept intact, saying that the matter should go to the review committee again. Subject to it.
That's what. But there was no, in the South's case, there was no vigilance case.
No vigilance case.
Let us see. Take down. You did not go to the tribunal.
Tribunal.
It did not function.
No, the tribunal is abolished since 2019.
It is 21.
21. Whether tribunal is abolished or no members are appointed.
No, abolished.
Abolished.
Since April 2019.
What? Petitioner, a compulsorily retired forest official of the state, is knocking at the doors of High Court for assailing the compulsory retirement order dated 20 January 2021. On the following grounds. One, the impugned order is punitive in nature and therefore could not have been entered without complying with the principles of natural justice. Two, the impugned order could not have been made regard being held to the service credentials of the petitioner, namely, he having earned 2 promotions and secured encomia and awards. 3, the committee constituted for adjudging cases for compulsory retirement did not take into account relevant factors, but its decision is colored by irrelevant factors. First, next paragraph. Don't number it, just below that. In support of the said submission, learned counsel for the petitioner drew our attention to the provisions of 71.
Yes.
Of what rules there?
Orissa Service Code.
Orissa Service Code, and pressed into service a coordinate bench decision of this court in is it reported? Compulsory. Just see that. In Sanjay Kumar Sahu versus State of Odisha. Next point. After service of notice, the OPs having entered appearance through the learned AGA resist the petition, making submission in justification of the impugned order of compulsory retirement. First up, Mr. Behura contends that the credentials of the petitioner are not that rosy as so to be made out. Semicolon. He did not declare the holding of assets, holding and acquisition of assets by his spouse. Semicolon. He also suffers BGR case number 47 of 2019.
That is Baleshwar Vigilance PS case number.
1 second. Which eventually is registered as
Baleshwar Vigilance PS case number 13 of 2020.
Yes, right there. Baleshwar Vigilance
case number
13
of 2020.
13 of 2020. Of which police station?
Baleshwar Vigilance case.
Baleshwar. of Paleshwar Police, PS police station, in which after investigation, charge sheet having been filed, charges also have been framed. Is it by Sessions Court?
This is special court.
Special court by the special court, jurisdictional special court. Semicolon. The committee, comprising of high functionaries of the state, after considering all relevant factors, has recommended the compulsory retirement, and accordingly the impugned order has been issued, and therefore a deeper examination cannot be undertaken by the writ court because of conventional limitations inherent. First. Next point. Having heard learned counsel for the parties and having perused the petition papers, we are inclined to grant indulgence in the matter as under and for the following reasons. A. Petitioner came to be appointed as forester by the order dated 8/12/1986. He secured his first promotion as a range officer with effect from 5/8/1996. First, further, he secured his second promotion to the post of Assistant Conservator of Forests on 26/9/2018. First, he has also secured twice the state award as the best range officer in 2015 for the year 2015, years 2015 and 2016. First of all, these glories have not been reflected in the deliberations made by the committee. First, that would constitute the first lacuna apparent on the face of the record. In Sanjay Kumar Sahu Supra, the coordinate bench observed that if the officer concerned was given a promotion despite adverse entries in ACRs, that is a fact weighing in his favor. First, it hardly needs to be stated when relevant factors do not enter the fray of decision making, that gives a scope and for challenging the orders, adverse orders. First off. Next point. Learned counsel for the petitioner is right in telling us that a compulsory retirement cannot be levied as a substitute for holding the disciplinary inquiry. First off, true it is that there were wild allegations against the petitioner, for which the DE was sought to be conducted. First off, however, after seeing his reply, the idea of holding DE came to be dropped. First off, this aspect of the matter has not been deliberated by the committee before recommending compulsory retirement. And that is how the second lacuna, the second infirmity enters the impugned order. First off, this view gains support from the coordinate bench decision in Sanjay Kumar Sahu Supra, which has secured imprimatur at the hands of Apex Court in which is that judgment you had given?
SLP number.
In SLP number 22484 of 2025 between Sanjay Kumar Sahu versus State of Odisha, this court decided on 7/4/2026. Next point. Admittedly, petitioner has put in a continuous service of about 3 decades.
Yes, more than 3 decades.
More than 3 decades. In his reply to the charge memo, he had specifically stated fauna and the flora, specifically mentioning the attack, physical attack he suffered at the hands of poachers, eventually resulting into his long hospitalization twice. First off, accepting said reply, the DE came to be dropped.
It was not dropped any time.
What happened?
It was not proceeded.
That is a case of dropping.
You have
came to be abandoned. DE came to be abandoned. Yes. First off, Mr. Behura's contention that no formal order has been passed dropping the DE would not come to the rescue of respondent OPs in matters like this, where a case of abandonment of intended inquiry emerges from the record. First, next, we also notice from the record that a vigilance case is pending against the petitioner, as mentioned above. Which aspect weighed with the committee even at the stage when no charge sheet was filed, much less the charges were framed. First off, now investigation having been completed, the police have filed the charge sheet and the special court has framed the charges, would not infuse validity in the impugned order ex post facto. First up. Next paragraph. All the above being said, there is force in the submission of learned AGA Behura that even if impugned order of compulsory retirement is quashed, no reinstatement can be granted to the petitioner who has already attained the age of superannuation, that is 60 years, pendente lite. He is also right in telling us that petitioner cannot be awarded back wages till he comes out victorious by securing an order of honorable acquittal in the criminal case, that is vigilance case, in terms of apex court decision in Ramlal versus state of Rajasthan. First, in the above, we are told, we are also told at the bar that because of the pendency of the said criminal case, the terminal benefits of the petitioner have not yet been settled. You said that. Yes, ma'am. Okay. First, what applies to the payment of terminal benefits should apply to the claim for the back wages for the period between the compulsory retirement and the date on which the petitioner attained the age of superannuation. First up, in the above circumstances, this petition succeeds. Second, a writ of certiorari issues quashing the impugned order of compulsory retirement subject to the observations here in the above. Yes. Little linguistic changes the order will undergo. Yes, after the practice. Just refer to Rule 71. Yes. That was on 18/1/2020. You say date of retirement. So his date of birth being 11/9/1964. And structure that order. Yes, it was that Sahu didn't put it for the citation in the local. Yes, argument. Many other times we have to complete the order.
Item number 13.
34.
Let's say kindly take up this matter. My lord, I had made a mention last week also. Matter could not reach the board. Let's may kindly take it up tomorrow, day after tomorrow, as per Lordship's convenience.
Tomorrow.
May I take legal to mention matters?
Is appealing.
Yes. I don't know. 35 my lords. This matter was specifically fixed by my lords to be taken up, but today it's not possible. May I pray? Day after tomorrow will be convenient, my lord. Can you take day after tomorrow?
21 kids. No, not chance.
So, my lords, in that case, on 8th, my lords, just a minute, my lords, may kindly appreciate. On 8th, my lords, item 35. But item 35 or 8th? Item 35, my lords.
Next week, yes.
But item 35, 8th. Item 35, 8th. 8th, my lord, my sir, item 36. Just a minute, 2008. 8th, my lord, item 35, kindly.
2008 matter.
Then 2009, 2008. 2008 punishment. 2008 punishment awarded dismissal of sir.
But 2025 case one.
That was the dismissal is the fine, not when the case is filed.
My item number 38
it is.
My lords, item number 35, my lords, sir, please to fix it as an urgent matter. But on 8th, my lord, I pray on 8th. On 8th.
No, on 8th, not, it will not reach.
11th. Any day, my lords, so convenient to my lords, but it must be kindly ordered to come.
11th, how many matters are those?
7.
11. 7. Put it on.
Item 36, my lord. State appeal. Notice has not been issued. Only delay has been condoned. Now it has come to our hearing list. And last week I also made the same prayer. Also directed to the for fresh admission. Notice has not been issued. Only delay has been condoned.
Delay has been condoned.
Yes. State appeal.
Has been not issued.
No. I am for the respondent.
Is it true?
Yes. Oh, the order is there, my lord. Order is there.
You take notice then.
I have already appeared. They have already copy served.
The name is mentioned there.
Yes, yes.
Mentioned.
Yes.
Then we'll take up somebody. What is the matter related?
Matter relating to national promotion. Juniors have been promoted.
No, it's nothing. Where is there? Emotional balance. Yes.
Yes. Family pension matter, my lord.
Family pension matter.
My lord, old lady.
38 also family pension matter.
13.
38 also family pension matter, my lord.
38.
38. Again, next week.
We are from the opposite party, yes.
Yes, sir.
It was posted at the very next time to the lordship. But you will take it someday next week.
Whether IO is here today?
No, my lord. His appearance was dispensed.
Let it come in the last week or third week of May. You have entry order in that?
No.
Nothing like that.
We just need to decide the point of.
Okay. That fraud and who somebody was present, etc.
Perfect.
36 next week. Next week I'll take my chance next week.
No, it's the personal, not a. Where is the urgency? That is what. That is.